Ready, sir?
They made a mention they are filing a vacating stay. So let us see. They're going to file. Let us see. Let us. We'll have it on Monday, but only after hearing the other side. And the list what you gave is only of those who are retiring by 31st. But now, by virtue of that order, they open the doors for thousands of people to come here. We can only say that if they are going to relieve, that would be subject to outcome of the pit. Just 1 minute. Now just wait. Now those which will P group etc. You give it. What you want to have it on Monday, Tuesday, only that. Just wait. I'll come back to you. Only those you want emergency posting. Wait till the other memos are given and then make a mention. Just wait. Yes, madam. Charge of that will consider it. What is there now? In case we record a finding that in case we find the case is made out, we'll consider it. No preemptive order without hearing the other side in such matter. After all, what you are seeking is a co-warrant. We'll hear it. This Wednesday, Monday, Tuesday, special bench and election matter. Nothing will happen. Nothing will happen. I will put them to terms. Wednesday. Wednesday. Only what you can't wait till Wednesday, you make a mention. Bharat. Wednesday. Thursday. Monday special bench. Thursday.
With your Lord's kind permission.
Just wait. Yes. Good. ನೋಡಿ 2012 matter. When did you file the writ petition? Why did you wait for so long? Not at the end. You can't come so late. No. Why did you wait for so long? You knew when you were retiring more than 1 year. What is the reason for you to file the writ at the last moment? We will see. We will only say, let it come. Let him retire. We'll put him to terms. In case something happens, we will extend it. Wednesday. No, that may be so, but I'm saying, why did you wait till when you knew you were retiring on Monday? Why did you file the writ so late? We'll see. Wednesday. Very good. Yes. Just wait, we'll come to it.
number 1, 1 to 7. Page number 2, 8 to 15. Page number 3, 16 to 20. Page number 4, 21 to 24. Page number 5, 25 to 29. Page number 6, 30. Page number 7, 31. Page number 8, 32. Page number 11, 33 to 38. 12, 39.
My lord, serial number 38, my lord. Seeking for a short accommodation, will file SO within a week's time, my lord.
We inform the other side.
Yes, madam.
A request made on behalf of the respondent. This is the matter week after next.
12, 39, 30, 42, 43.
Yes. You appear for petitioner. 2011 matter. Have you informed the other side? You have to inform the other side.
Serial number 41, my lords, I represent for respondent in this.
They are asking for a short accommodation.
Please,
We'll
my lords.
relist
I'm
it on
on.
next week.
Please, my lords.
9. Yes. Have you informed the other side? At request of petitioner, relist the matter on.
Your Lordship, serial number 49, Your Lordship.
Yes.
Your Lordship, I am appearing for the petitioner in this matter.
Yes.
Your Lordship, in this matter, we are engaging the senior counsel, Your Lordship. May kindly have it on some other day. And I have informed the other side, Your Lordship.
Correct, but that by itself is not a ground, though I'll give time. At request of petitioner, relist the matter.
With your lord's kind leave, serial number 46. For the
Yes.
respondent. I seek for a week's adjournment, your lordships.
Have you informed the other side?
I will inform the other side, your lordships.
From next time, please have a look at the cause list note. On top
Please.
of the cause list, you are required to inform in advance.
Please.
You have to inform the other side. Report
I will
it
do the
to
needful. I will need it. I'll do the needful, your lordships.
at request of the respondent. List the matter on 9.
Much obliged.
Yes, you take out notice. Let us see, let us see. The government advocate, AG is directed to accept notice for respondent 1 to 5, emergent notice to respondent number 6. Petitioner is at liberty to take out notice to respondent number 6 by way of and summons as well.
Appear for the petitioner, my lord. But this is a terminal benefits has not been settled, my lord.
Canara Bank, any standing?
My lord, Santosh S. Nagarale, my lord.
I issue notice to the petitioner with learned counsel Santosh S. Nagarale is directed to accept notice for the respondent.
Serial number 3.
I appear for the petitioner in this case, my lords. The petitioner was initially appointed on daily wage basis. Thereafter,
Take out notice.
yes, ma'am. Only first respondent is government, others Jilla Panchayat notice.
AGA is directed to accept notice for respondent number 1. Emergent notice to respondents 2 to 4. petitioner is at liberty to take out notice by way of hand summons as well.
They say that as per the record, it's supposed to be retired in 2016. But nevertheless, they previously 1 year they
Let us see. Take out emergent notice to the respondents. Any standing counsel? The petitioner is at liberty to take out notice by way of hand summons as well. Use the mic, use the mic.
Challenge the annexure G, my lord, passed by the Commission of Disability. They had no jurisdiction to pass such order, my lord, because, my lord, this is matter pertains to promotion. If you agreed, my lord, he is the government servant, my lord. If he agreed, my lord, approach the KSAT. Instead of that, my lord, he approached the Commission of Disability and for promotion, my lord. Annexure G is the order passed by the
Picture. Page. Yes.
ಇವರಿಗೆ ದಿನಾಂಕ 23/12/2013 ಸ್ವೀಕರಿಸಿ ಸದರಿ ದಿನಾಂಕದ ಎಲ್ಲ ಸೇವಾ ಮತ್ತು ಆರ್ಥಿಕ ಆದೇಶ ಜಾರಿಯಾದ ಕ್ರಮ ಕೈಗೊಂಡು ಅಂಗವಿಕಲ ವ್ಯಕ್ತಿಗಳ ನ್ಯಾಯಾಲಯಕ್ಕೆ ವರದಿ ಸಲ್ಲಿಸಲಾಗಿದೆ.
No, under section 82, you are saying that the authority doesn't have a jurisdiction to confer such a disability.
As per the annexure A, my lord, in the year 2013 itself, my lord, they given the promotion to the petitioner candidate, my lord.
Correct, but what I want to know on the jurisdictional point, you are saying that it has to come before the administrative tribunal, and under the act, such power is not available. Let us have a look at.
Section 80 and 82.
Let us have a look at. On what ground he has complained to the authority?
Please, my lord, as per the annexure A, annexure A, my lord, in the year 2013 itself, given the promotion to the petitioner here, my lord. He has forgive the promotion, my lord, as per the annexure B, my lord. He has given the representation. You will read, my lord, page number.
He has given it up.
Page number 24, my lord. Annexure B. Page number 24, my lord. Before that, my lord, kindly see the annexure A. Page number 19, my lord.
But he's saying that
20, my lord. You want the page number 20.
correct, but he's saying that because he couldn't climb up, he gave it up. There was no lift.
Please, type to copy annexure 25, my lord. Sorry, annexure B, page number 25, type to copy, my lord. 25, my lord. Type to copy.
Yes.
ಮೇಲಿನ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧ ಈ ಬಾರಿಯ ಅಧೀಕ್ಷಕರ ಹುದ್ದೆಯ ಬಡ್ತಿಯನ್ನು ನಿರಾಕರಿಸುತ್ತೇನೆ. ಮುಂದಿನ ಬಾರಿಯ ಅಧೀಕ್ಷಕರ ಹುದ್ದೆಗೆ ನನ್ನನ್ನು ಪರಿಗಣಿಸಬೇಕಾಗಿ ವಿನಂತಿ.
He's saying that because there's no lift, he had to give it up, the promotional post.
At present, my lord. In the year 2013, my lord, he has given up, my lord. Next 2016, my lord, as per annexure C, given the promotion to the petitioner hearing, my lord.
He's been granted promotion.
Annexure C, my lord, page number 26, my lord. Page number 26, my lord.
Issue notice to the respondent. Issue notice to the respondent in light of the contentions raised, including the jurisdiction of the authority to have passed the impugned order. Subject to further consideration, there would be stay of the order.
Annexure G, my lord.
Annexure G.
Dated 31/21, my lord.
Dated 30th
First
January
January 2020.
21.
21.
But then you have come more than 1 year after you have appointed it. Have you given effect to the order of promotion?
No, my lord. That's why.
Till the next date, issue notice to the emergent notice to the respondent. No representation on behalf of the petitioner.
I appear for the petitioner on serial number 6, my lord.
Yes.
This is with regard to the payment of pension to a professor in Bangalore University, my lord. There was an earlier.
Take out notice. Bangalore University. Who's there? Bangalore University. Third council. Rajendra Kumar Singh is directed to accept notice for the respondent. Yes.
My lord, there is an interim prayer that I have also sought, my lord, with regard to the stay of an endorsement dated 16/10/2021 that was filed in the previous writ petition, my lord.
Let us see, you serve a copy, I'll keep that open. And then we here consider the interim prayer.
Obliged, my lord.
The request for interim prayer is kept open.
Much obliged.
Yes, who's there for BBMP? Now, what we can do is, now you have said that non-consideration, non-application of mind, because that other authority had asked the petitioner's explanation. So what we can do is, you serve it, we'll have it in the same stage. And then if the case is made out, we can dispose it at that stage itself, instead of keeping it pending. Now, the short question is whether they ought to have waited till the report came. And you are saying that they should apply their mind on 10/3. So if that is the only question, petitioner's explanation must be got.
that response to my expert. All of a sudden, the file which comes for my promotion, before this promotion is proceeds to submit the report stating that the case to which is required and suspension. That is the reason, the very reason is that the report was not do not expect that the promotion. We have forwarded this report. Now, this is a report now. He has postponed my and see now the date is 1/2/2022. I submitted my explanation on 5/2/2022. They do not permit me as copy and now they have to handle. When the file for promotion comes to us, they put up the file stating that it is a case to which is expired and this is it is so intentional. I think we will come to immediately permission of to submit the explanation.
Shall we have it on Wednesday and dispose it off in the same stage?
I understand now that it's a case where they have to seek my explanation before placing a suspension. It says that they are not relevant. Not the notice says that I should not have put a petition that experience the physical nature of work, not is a manual. If the government petition has specifically stated that the experience is manual, and this is the first notice not a rush.
That is on merits.
The very notice that was issued is the sole intention that I cannot have put a condition that asking the experience is similar nature of what are the conditions. And that the basis for initiating.
Where do you get that?
Yes,
Yes.
Last ಈ ಗ್ರಾಮಗಳಲ್ಲಿ ಯಾವುದೇ ವಿಶೇಷ ಇರುವುದಿಲ್ಲ I submitted explanation to that one. That is actually certified. Thereafter, matter was once again referred to the investigation by the entities is technical. That companies are also reported. They will seek explanation regarding this.
Where is that report?
But that report was not
Yes.
Look at page 89 last main lines. ये तो फिर ये फिर डेटा बढ़ने से का सारा संदर्भ के दिमाग पर डेटा पर अंदाज करके जो इसका शिक्षा है तो ये अंदर जाता है इस सेक्टर में संस्थान में प्रकार आ रहे हैं ये मालिक से आगे सभी काम पर रेगुलरली विचार करना सारा क्योंकि आगे मान
This is prior to the order of suspension. Order of suspension.
And they receive no response. This is the promotional file. The report is submitted stating that initiate inquiry. Last we will see the answer to that which are produced. That page. That page 94. on 4/22 and the lapse of another 4 months. And when came into the March of 2022.
This is the proceedings of your suspension proceeding.
Yes, fine. In this matter, the court as far as the says that the fifth case to initiate department of inquiry, therefore it has to place specific NEC to also suggest that she will be appointed as the inquiry officer.
Herself.
Yes. Based on this matter, because application of mine, the third respondent has proceeded to place.
Where is that recommendation that she has to be appointed as inquiry officer?
Here, page 94,
Yes.
someone that preparing company improvement He's the one who is the superior officer, which he has to appoint. But kind of something and also what the starting at page.
So now, so far as the suspension we can consider, the remaining will have to see. Departmental inquiry will see.
Suspension order must not be completed. If inquiry is to have another letter, both the inquiry PCC course says that you must seek extension. But the court respondent does not have provided the so there will be any extension to me for placing them as suspension.
The petitioner has contended that the what is that TVCC? Is it? What is the Technical Vigilance Committee cell, which is the investigation wing of BBMP, was referred with the matter and had opined that the explanation of the petitioner is to be obtained, which finds a reference in the proceedings of the respondent BBMP maintained relating to the suspension file of the petitioner. He submitted that though such observation of the TVCC was noted in the proceedings on 3/1/2022 without taking note of observation of the TVCC, order of suspension has been passed. In light of the contentions raised and subject to further consideration, there would be a stay of the order of suspension at Annexure P. So now, since we have stayed it, they legally they are.
Therefore, the agency may not proceed. They said that there is no specific direction by the board to consider the claim for promotion. And the identical circumstances to honest candidate, where there was a direction to consider the claim for promotion to the DPC not has a candidate promotion. In my case, they have refused to grant because there is no such order.
Now the DPC cannot consider if there is an order of suspension.
Yes, you have referred it.
It's further clarified that in light of the interim order passed, the EPC is at liberty to consider the case of the petitioner in accordance with law, which would be subject to final orders to be passed. AG accepts notice for the first respondent. Learned counsel Shri M.A. Subramanian. M.A. Subramanian is directed to accept notice for respondents 2 to 4. Normally, ex parte is only an exception. Yes. Just on the mic, Right now.
Page number 11. Page number 12, my lord. Point number 5. ತಹಶೀಲ್ದಾರ್ ಅಥವಾ ಉಪ ತಹಶೀಲ್ದಾರರಿಂದ ಪಡೆದ 3 ವರ್ಷಗಳ ವಾಸಸ್ಥಳ ದೃಢೀಕರಣ ಪತ್ರ. But the fourth respondent have not submitted, my lord. The year page number annexure F, my lord, page number 19. She is married in the year 2020, my lord. She is not a resident of the Gram Panchayat, my lord, Cholo Gram Panchayat.
Take out notice, sir. We will make the report. If she reports, it be subject.
Yes, I already reported the appointment of the fourth respondent subject to that.
Notice. AGA accepts notice for respondent 1 and 2. 1, 2 and 3 is it? 1, 2 and 3. Emergent notice to respondent number 4. Petitioner is at liberty to take out notice by way of and summons as well. The functioning of the fourth respondent is subject to orders to be passed in this section.
Appear for the petitioner, my lord. This case, my lord, pensionary benefits has not been settled, my lord.
AGA accepts notice for respondents 1 to 4.
Similarly, these persons have already obtained an order from the Honorable Court. Page 63 is the order of this Honorable Court.
Page
63. Petitioners herein also, my lord, were appointed as civil engineers, my lord, under the scheme.
Same project.
Same. These petitioners, my lord, in this petition, my lord, are from R.R. Nagar, and the petitioners in the present petition is, my lord, Mahadevpura as well. The scheme is GIS scheme, centrally sponsored scheme, my lord. They were also appointed, my lord.
This will appear for BBMP. AG accepts notice for the first respondent. Learned counsel Shri Ashwin has already accepts notice for the second respondent. Now they say it's covered by, give him a copy.
Yes, sir.
At annexure L, they say to verify. If it is so, then we can file a memo, then we can close. I'll have it week after next day. You verify from it. If their instruction is it's covered, you file a memo, we'll dispose it. This is the matter week after next.
Okay, then. 11.
Let's 11. I appear for Mr. Somshekhar for the petitioners.
Lakshmi Narayan is appearing. He pays for a 10 minutes passover. Kindly passover. He will appear.
Passover. At we'll take it up at 11:30.
Very
11. Same. Yes.
This is not a, this is also we are not a support
Like the arguments today you mentioned. Last time you mentioned that matter set down for arguments in the main matter. Find out on 11/3/22. So it is stated. So if it is so, it may have, let us. So we'll have it on next Friday. Taking note of the observation made in the order dated 11/3/2022. We list the matter on the CGP to indicate the present status of the main matter before the trial. First time. Hope so, is it? Huh?
direction to the earlier, but on day of
Page?
49. Investigation 8868 of 2019. Order dated 5th October 2020. But also that given a direction to the trial court to execute the trial within the period of
Accept notice for the first respondent. Emergent notice to the second respondent. The status of proceedings before the trial court to be intimated by the next date. Date for it. Next Friday.
Sitting at 15th.
Correction to the course of telecom operated Sanskrit University.
Who appears for the respondent? Who is the contesting respondent?
Not coming.
Huh?
Last time also it will be compared. Because he is enjoying the post merits, he is not entitled to vote that post merits because he has no qualification as per the notification. This is page number 18 minutes. The qualification.
So the third respondent is working under the second respondent. So who appears for the second respondent? Now we'll direct notice to be served to him through the second respondent. Then
The others are also filed represented.
the third respondent will have notice served to the second respondent and take it up so that tomorrow they don't come saying we have not heard, etc. The notice to the third respondent to be served to the second respondent. Necessary process fee to be paid forthwith. You want to take out by hand summons once, you can try. The petitioner is also at liberty. No, the hand summons vehicle, either we'll try and then we'll list the matter.
Respondent 2 has already filed a replacement matter.
What is their stand?
They said that he has a required qualification.
Let us list the matter. Date could be week after next. We'll have it in 9th. You just intimate R2's counsel. So let him serve the notice, then we'll take it up.
The respondent number 6 to 10.
It has to come in B group.
IA copy has to be signed.
Because when I was watching promotions have been impacted. That's respondents the post of office. Therefore, they have filed application. They are already there as parties. But here, it is ineligible persons have been promoted.
Let us see. Let us.
But not rated it is for hearing also not because
Correct. Now it has to come in.
she was entitled for the post of professor itself in India.
Let us see. Let us. So let it come in B group, not in the IST.
They have filed an IA for production of documents, additional documents.
Therefore, it is proud.
So we'll list it in B group and fix a date. Let us see if it is.
Kindly fix a date.
Serial number 15, my lord. I'm appealing for respondent number 2.
Serial number, this is serial number 16. 15 was called out. Now
Please, ma'am.
in serial number 15, we have directed notice to the third respondent to be served by you.
Please, my lord.
So you take steps to serve the and the report
Please,
is listed next Friday. Yes,
Please,
16.
I'm for respondent 2, my lord.
So now we'll put it in B group and we'll have to hear it.
Because my lords, all ineligible persons have been given the granted promotion and the petition has been overlooked and though she was eligible much before all these respondents.
Let us see. Let us. This is the matter in B group on date 15. But I will go chronologically only. Let us. Yes.
Third week, my lord, 17, you will have 5 statement of objection. On the last date of objection, court had directed you to take notice.
16. 16. Yes.
16 minutes.
16.
I appeal for the petition. Not in the last hearing, my lords,
Yes.
respondent had filed a memo for calculation. My lords had directed me to enhance the amount that was quoted in the first round of settlement, my lords. Now, however, my lords, the respondent has a new commissioner, so it is taking some considerable time, my lords.
What? Have you given that?
We have financed our proposal, my lords. It's still pending consideration before the respondent.
Did you take instruction? Huh?
Write a memo of calculation. I will get the instruction.
That you have you served it to them?
My lords, that is served, my lords, and
They are ready to pay according to that.
yes, my lords, we've enhanced our proposal also, but the respondents are yet to revert, my lords.
One lakh 75,435.
That's 75,436 total.
That you are ready to pay. So have you have filed a memo saying you are ready to pay that or what?
My lords, sir, directed in the last hearing, my lords, that we approach the respondents and enhance our proposal as in terms of the memo for calculation filed by the respondents. So we have proposed, my lords, they are yet to revert.
Then you find out.
Find out and I will let the court.
So we can close it if that is there. At request of when do you want it? Friday date. Huh? 10th. Close it, you will see. Yes.
Critical matters, Lord. Ordinate bench of this honorable court, my lords, my lords, that competent authority is, my lords, the managing director of KPTC. He can impose a penalty. I can produce, my lord, for your lordships.
What is the challenge?
challenge is not to initiation of the inquiry by the local both respondents. Not the petitioner Manoj pursuant to a inquiry Manoj, the recommendation was made for service. Not this challenge cannot require lordship.
Interestment is challenging.
Investment cannot and cannot dismissal from service cannot they content cannot that the managing director cannot ought to have imposed the penalty and not the local itself. Ordinary bench of dishonorable court cannot set page 82 82 page 82.
He only has produced. Yes.
81 minutes, I'm sorry.
Yes.
Petitions are allowed in part. Second show cause notices and orders of penalty passed in all these cases are quashed. The matters are remitted back to the hands of the managing director of TTCL. The managing director would be at liberty to issue second show cause notices, enclosing the copy of enclosing the report of the inquiry officer and recommendation of the locator to which the petitioners would be at liberty to submit their replies, and the managing director shall pass appropriate orders in accordance with law after following due process of law. The aforesaid procedure of issuance of second show cause notice, giving replies and passing appropriate orders should be concluded within a period of 6 months from the date of receipt of the copy of this order. The petitioners who are as on date continuing to work in the present matters shall continue as such with compliance with the aforesaid direction.
Now the managing director is passed, which he has again called in question.
The petitioner has retired from service on 31/7/2000. Benefits of service.
Let it come in B group. No representation on behalf of the petitioner. List the matter in B group.
Wherein the petitioner who is now a professor is being granted promotion in the year 2007. The Lord overlooked and all juniors have been already given promotion, and he was afraid of even applying for the post of director. Therefore, my lords, the matter also needs to be heard. And now they have also moved the files of both, file for the post of both medical superintendent, and the 11th respondent's name is also clear. That's how they have been overlooking all the petition promotions of post.
Pleadings are complete.
Application for early hearing is made, rule is not issued, rule is issued.
Yes.
Final hearing.
No, along with the other matter, not the same day.
Same day, but rule is not issued.
Because both are similar matters.
Let it come in B group. 2018 matters, it will be up in the list.
So, Lords, now because he's going to the problem is, my lords, all juniors they have been given. They are not even granting him from the date of 2000. He became eligible.
Correct, in the highest stage, how we can take it?
My lords, not on the highest stage. I'm not.
So let it come in B group on the same day I'll put it.
Senior number, my lords, 16, which is my lords, on the same day, because both belong to the same.
It's the matter in B group on date, same date. 16. If you want final disposal, you file your synopsis. If you want final disposal, file your synopsis. Yes.
Commissioners were appointed as Karnataka and contract cases under the in the year 2002.
Who appears for the fourth respondent?
I am for the respondent.
Contesting respondent.
No. The parliament.
Who is
Third respondent is the contesting party. The representation have been given the third respondent, and also endorsement is issued by the third respondent.
You filed your.
Yes, I have already filed the objection.
State. You file your objections.
Whether their service since 19 years, Recent LFS and they removed from their service. They are present their age 42, 48, 48.
You file your objections by the next week. Objections to be filed by next week. List the matter on 15. No representation on behalf of the petitioner. List the matter for final hearing. The week commencing from 27th of June. IA is allowed. Yes, next.
21 minutes.
21 I posted for hearing in the week commencing from 27th of June.
Can it be in B group, my lords?
I already posted it. Let us see. On that day, you make a mention and we'll see what can be.
Because rule is not yet issued, my lord. That's the reason. In
You said
fact,
for early. You filed an IA for early hearing.
yes, my lords, I have filed, but I believe, my lord, rule is not issued, my lords.
Then you clarify that position and make a file an IA if you'll consider it. Yes.
22.
Please.
Number 22.
Where is the other side? We will relist it. Let us see. Pass over or relist it on some other day. No representation on behalf of the respondents. Relist the matter week after next. Date 10. Interim order earlier granted is extended until further orders. No representation on behalf of the respondents. Yes.
But they're seeking arrears in salary, my lord.
Just 1 minute. Now, who appears for the respondent 1 and 2? State. Is it? No. AGA accepts notice for R1 and R2.
They filed their objections also.
No, in the cause list in both the matters. Yes.
But short time that we have covered for this reason, they only seeking arrears, my lord. Their pay came to be revised as per the central government pay scale. My lord, insofar as colleges which are falling under the law department, the pay scale was not increased. But colleges coming under the education department, my lord, pay scale was increased. Even though, my lord, the central government has given the funds to the state government to be dispersed to the professors, they have not done so. They have modified the relevant clause so far as law department is concerned, and they are not giving the arrears itself.
No, this is what are the facts?
The facts, my lord, are registered, my lord, are professors in various law colleges, the doctors estate. Now, my lord, as by clause A, the central government, my lord, they issued a notification saying that annexure A, page 25.
So they are working, they are law professors in government college.
So government, private aided college. They asked, they have not asked, they have given. All we are seeking, which has been revised from a retrospective date. For those 4 years, my lord, from which retrospective operation was given, they have to pay me the arrears. Now, my lord, in the state, my lord, there are 5 government law colleges and 13 private aided law colleges, of which, my lord, 5 government law colleges and 7 private aided law colleges come under the education department. The balance 9 private aided law colleges come under the law department. But colleges coming under the education department, my lord, they have paid arrears.
Aided.
Yes, they have paid arrears. Only for the colleges falling within the ambit of the law department, they have not paid arrears. Not only this, my lord, this is insofar as law colleges are concerned. across the state, my lord, there are around 401 first grade degree colleges and 315 private aided law colleges across various subjects. All of them have been given the arrears. It's only the law colleges falling within the law department, they are not being paid arrears. Agreed by which, my lord, I will go this honorable.
What is your stand? Realistic, no, if what they are saying to be correct, then you take a decision. Why do you need the court order? Relist the matter on 15th.
My lord, he had given a representation giving to their knowledge all these questions which are involved. For which, my lord, we have replied because there is a delay on our part in giving this representation.
It is. Yes.
Yes, sir. I have been appointed in the place of the petition. Well, basically, the appointment of the petition is a temporary petition. At any time, without information, they have to be heard for power vested with the government. Kindly see the page number 30, Annex A.
Now, pleadings are who is the contesting respondent? Who is the contesting respondent?
Petitioner is the contesting petitioner. I am the appointed in the place of the petitioner. I am come as a contesting respondent. They were applied applicant for impeding and appointed to the proceedings.
2 of 21 has been filed, seeking to be included as the respondent. Pretending that the pleading applicant has been selected as per the order of 30th August 2021 and the stay of annexure F and G prejudices the rights of the impleading applicant. Accordingly, the impleading application is allowed, taking out of these submissions. No objections are filed to this.
No objection has been. The last date of hearing is put directed to the government advocate to conduct.
So to the impleading applicant,
No objection.
no objections are filed to the impleading applicant. Necessary amendment to be carried out in the cause title. No representation on behalf of the petitioner. Relist the matter on 16th. By then you file your objections. Objections to be filed by the state by the next date. Carry out the amendment.
Where I am appealed for the petitioner. My lord, I filed this application for amendment. After my lord passing the final order for punishment of compulsory retirement. Subsequently, another order was, my lord, a communication was issued and that was filed along with the statement of objection. That was called in question by me.
We'll allow the amendment. This only will decide. Why again one more?
We permitted to file our objections for the main after.
It's part of my lord, the order which is challenged now in this writ petition is a part and parcel of this lord, the order now I want to amend. My lord, I don't think objection from the other side is required.
IA 3 of 22 for amendment is allowed, taking note of the amendments made in the said application. Necessary amended petition to be filed. Respondents to file their statement of objections to the amended amendments within a week's time. List the matter week after next.
Meanwhile, I will file an
within 2 weeks. List the matter immediately thereafter.
Meanwhile, I will file amended petition also.
Sir is working as a principal in the autonomous college in the degree college. And the respondent, the government enhanced the retirement age from the year 60 to 62 years. And we are working on par with the government colleges and other university colleges.
This is, I will only say, relieving of the petitioner will be subject to orders to be passed. Let them
Yes,
get
sir,
it.
and it's there. His copy is also in the market.
No stay. I'm not going to give any stay of retirement.
Extension,
Put it.
please.
This will have serious implication. Without hearing, we cannot. I'll only say that relieving will be subject to orders to be passed.
So that is the order.
I will not direct for continuing of services. That only after hearing them.
Yes, but in terms of that order.
No, this cannot be done now. How can we say their services to be extended? Only after hearing them. If you are relieved, that would be subject to outcome of the petition. See, we can't rewrite that. Only after hearing, if the case is made out, we can see. But now can we pass a blanket order extending the retirement age?
Yes, madam. I am also seeking subject to the
So that after-
whichever is earlier, madam. 62 years or disposal of the writ petition, whichever is earlier, madam.
We cannot. Only after hearing them, we'll consider the interim
Please,
period.
madam, that in terms of the said order maybe.
I can't pass an order in terms of that order. We can't extend the retirement without hearing them.
Yes.
AGA accepts notice for the respondents 1 to 4. The relieving of the petitioner is subject to orders to be passed in this petition. Request for interim prayer is kept open. This is the matter week after next.
Living of the
That's what we have seen.
petition andre relieve ಮಾಡ್ಬಿಡಬಹುದು ಅಂತ.
Correct, that you can't avoid. Interim relief, you are requesting for extension. I'll fix a date, you argue on that. We'll see. Any private, if this already question is considered, it's a different matter.
Not to relieve until next date of hearing and all.
That we cannot, but we will consider interim prayer on the next day.
Submission is already interim order is there, madam. In terms of that order, it may be passed. It's already there.
No, there's nothing in that. What it
is
says.
continuing, madam, until the next date.
We don't know the facts. We don't know the facts of it. We have to hear the others. No, on this, no, that will hear.
Till next date, madam, not to relieve.
We'll hear this matter. Yes, when do you want it? It's the matter on
30th, you will be getting retirement.
No, correct, but we are saying that even if it is done, we will kept that consideration of interim prayer open. On 15th.
1560, that's it.
This is the matter on 15th.
Till that date, let him not relieve.
No, that is. What is this matter?
It's a bail matter, my lord, because SCST Act is involved, it is converted into criminal appeal.
First time, is it? First time.
Second time, my lord.
But in this case, Lordship, my lord, victim has made a requirement. But as father or mother,
My lord, there are actually two appeals emanating from the same incident. And one of the cases, last time itself, Honorable Justice Nawaz had already
Don't
directed.
mention names. Don't mention names. Don't mention names of judges.
The Lordship has already directed to serve notice to the victims also, my lord. And
So what has happened to the notice to the father of the victim? Notice nodi ಏನಾಗಿದೆ?
Rashid had already directed at that time itself to issue notice. It is long pending, my lord. He has been in jail for 3 years, 2 months.
Notice ಸರ್ವಾಗಿಲ್ಲ.
ಸೆಕೆಂಡ್ ಮ್ಯಾಟರ್ ಆಗಿದೆ. ಮ್ಯಾಟರ್ ಆಗಬೇಕು ನೋಟಿಸ್.
We'll have it next Friday. By then you complete whatever instructions you have. Now notice must go to the father.
Lordship has directed, but since they are not.
They make a party in the murder.
Allah, he is a party. Father of the victim is a party who is the second respondent. In
I request my lord issue notice to the father of the victim. In the meantime, I also got a respect to
issue notice to the second respondent in Criminal Appeal 251 of 2022. A notice to be served also through the jurisdictional police authorities. Returnable by next Friday. Next Friday. Then complete your instructions. He's in custody since?
Yes, my lord. Since 3 years, 2 months, man.
3 years.
3 years, 2 months.
What is the offense?
Folks on.
But morning I received information from the police constable, sport police constable. He already, my lord, 16 witnesses are already examined. Remaining witnesses are
My lord, actually, your lordship had earlier given direction to complete the trial within 1 year. The direction has not been complied with. It's more than 2 years there afterwards. About 16 witnesses have given evidence. Another more than 50 are still pending.
Let us see that you make a submission. How many more witnesses you are going to examine? What is the time? Apart from that, we'll see. See, bail proceedings cannot be amount to a punishment. Now, if the major witnesses have been examined, then the rest is a matter for trial. So you find out who are the major witnesses. If their examination is over, then you can't keep it. Finally, what sentence you pass is a different matter. Why do you keep him if the main evidence is over? You get instruction. List the matter on next Friday. Both.
Say number 11, Somsekhar.
My lord. Yes, my lord. Senior.
Yes.
Senior is coming now. One second. Just 1 second.
For the petitioners, my lords, in these two matters, your lordship may kindly appreciate that for employees in an educational institution who harass the professor after barging into her chambers and demand a written apology from her, Again, go in the evening at 4 o'clock and say, if you don't give written apology, then we do not know what will be your fate. And she had to run for shelter. The tribunal says, it's not a serious matter. After all, it is abuse. So kindly see, my lords, I would like your lordship to see at page 187. Kindly see at page 187, paragraph 16. Could your
What
lordship
is
get
in challenge?
my lords?
What is in challenge before this court?
What is challenge?
What is in challenge before?
My lord, what is challenge is these two employees. Both of them have been given interim relief of 50% of the wages during the pendency of the proceedings. One of them has already retired. In respect of the retired employee, the court has said 50% of the terminal benefits be given. In fact, we have given 100%, we have settled his account. More than 5 lakhs rupees we have paid at the time of dismissal, and we have settled his account. Why 50%? We have paid 100%. And to that person, from the date of dismissal till date of superannuation, that is about 14 months, 50% wages be paid is the effective order against me in one case. In the other case, from the date of dismissal, you pay 50% during the pendency of the proceedings. My submission is this, man. When a matter goes before a tribunal and the courts have uniformly held, interim leave may be given, may be considered only if a prima facie case is made out. Now, kindly see what the tribunal thinks as a prima facie case. Just permit me to read a few, about one or two paragraphs. Kindly see page 187. At paragraph 16, my lord. May I just read this, my lord?
Yes.
On perusal of these charges, which are concerning to the riotous and disorderly behavior in the college premises, threatening, intimidating, indecent and unruly behavior with the head of the department and women employee, failure to show proper respect to the head of the department, committing nuisance in the institution, shouting, using of indecent language, misbehaving, and being rude with the head of the department and employee of the college, etc. So looking to these charges made against the appellant shows that as per the contention of the appellant, one Srimati K.L. Jyoti, working in the digital lab number 8 of computer science department, had requested through letter to the union regarding the harassment given by the head of the department, Dr. G. Shobha. So when one of the employees submitted a letter to the association, then the appellant, being the vice president and also active member of the association, interacted with the head of the department, tried to pacify their dispute. Taking advantage of the situation, the respondent management framed these charges, and after inquiry was removed from the service. Then paragraph 17. Here, from the prima facie looking to the charges framed by the respondent institution, it clearly shows that it is only a misbehavior, shouting indecently and creating nuisance in the college, etc. But looking to the circumstances, when one of the employee complains to the association regarding harassment given to her by the head of the department, that to a woman, then naturally being vice president of the association, the appellant raised the dispute with the head of the department, settled the matter. From where the tribunal got this, that he settled the matter, nobody knows, because it is nobody's case that the matter was settled. Misbehavior is acute, that too with a woman. So how could the tribunal say, he has a prima facie case, and therefore I proceed to grant interim relief? That is number one. First contention. Second contention, inquiry was held. Inquiry, whether it's fair or not, has to be determined. Division bench of this court, single judges of this court have taken the view that when inquiry is held, till the inquiry is set aside, there is no way you can grant interim relief. I produced a few judgments, Milord. Kindly have a look at the judgment which I have produced. And in fact, the one division bench judgment, kindly see, Milord, at page 4 of the compilation of the court cases which I have given. In that, could your lordship hear me, my lord?
Yes, yes.
Page 4, my lord, in the paper book of
Yes.
where I have produced the judgments, there is one judgment of TT Limited versus R. Subramaniam and others, a division bench judgment, which was considering similar aspects. Kindly see in this case about in the first paragraph, about 6 lines from the bottom, we are in respectful agreement of the Shurvate. We are in respectful agreement with the view taken by the learned judge. In the Mysore Cements case, that is the first one which I have produced. In the Mysore Cements case, that is single judge, this court held that when an application for interim relief is made by a workman during the pendency of an industrial dispute, the labor court in the first instance should consider as to whether the domestic inquiry was valid or invalid, and thereafter proceed to grant the relief if the domestic inquiry was invalid. Now, this is what the division bench agrees with the single judge and passes an order. The tribunal should at least look into this and find out whether before holding the inquiry as not fair and proper, could he have granted interim relief at all? Now, this also runs against the respondents. Inquiry is held, there is an issue framed as to whether the inquiry is fair and proper or otherwise by the tribunal. Issue is framed, issue is not tried. Straight away you proceed on an application made by the respondent for interim relief, and then prima facie you make a very light work of the serious matters, simply abusing. So 10 people led by the vice president can enter into the chamber of the professor, who is a lady, and threaten her, saying, you give apology. And when she was running to the principal's cabin, they followed her. This is not sufficient. Are we going to compensate these people for these kinds of misconducts? We'll have no discipline in educational institutions, even among the teaching staff, non-teaching staff. Therefore, my submission is, for the purposes of admission at this stage, I am of the firm view that this matter needs to be heard in depth, a law laid down properly, comprehensively, I would say. In the meantime, there should be an interim order of stay for 2 reasons, which is, one is, each one of them have got 5 lakhs and odd, just about,
When they were terminated.
when they were terminated about 2 years back.
2 years.
So there is it is not as though they are without money and that they are on the street. One of them has in fact retired. Therefore, my submission, granting interim relief would send totally wrong signal to the teaching and non-teaching staff of this educational institution, which has a great reputation for good work over a period of time. And therefore, my submission, kindly admit the matters, grant interim order as prayed for. Much obliged.
Now, out of the 2 employees, 1 person has retired.
One is retired.
What about the other employee?
Other employee is dismissed.
Interim relief is to the effect of
50%.
50% of the salary which he was drawing.
From the date of the
That would come to around 25,000 rupees roughly in respect of
14,000.
one of them.
14,000.
14,000 in respect of the first employee, 50% to. Second person, 50% is 24,000.
Yes, what do you say?
There's grievance of a co-employee was taken to the chamber of
Mic is on.
the grievance of the co-employee was taken by the association led to the chamber. The management case would be, there is a complaint by the professor and the principal. Therefore, you have misbehaved. Complaint is not domestic inquiry. And ultimately, they are putting more than 30 years of service and other business. The 2 questions, my lord, which my learned friend has to cross. This is one domestic, the interim relief.
any issue on a preliminary issue cannot be challenged. He has to avoid the final order. That is one. But the second one is an order of dismissal is passed by the management, private management. The Karnataka Education Act, there shall be a prior approval by the competent authority. Such an approval has not been taken. So therefore, it is a totally ab initio. Third aspect of the matter is an order of suspension has been passed. It automatically lapses on expiry of 90 days. Earlier, after the main relief in the application was there is a gap of 1 year. Therefore, at least give me that 1 year so that my learned friend must have said 5 lakhs rupees has been sent to the mortgage house so that we have to live. We have to survive. Both the people are staying in a rented house. So far as one Parameshwar, Guru Brahma is concerned, he is retired. WP number 323. Daughter is studying in the final year, business management. And so far as Paramesh is concerned, he has got 2 daughters. One daughter died a month back because of cancer. Whatever the house which he has sold it, and he could not save his daughter. Both of them are in financial difficulty. Whatever the little retirement benefit which they got it, they have been mortgaged the house, they are surviving. They must litigate the matter. The most important aspect of the matter is, if an order of dismissal is passed under the Karnataka Education Act, there shall be a prior approval. Therefore, prior approval has not been taken. They have been kept under suspension for more than 1 year. An order of suspension, my Lord Justice Vikram said in 2015, an order of suspension, the tenure would automatically cease to exist on expiry of 90. One of the prayer in the application for interim relief was, give me the 1 month salary. You will also direct them to pay 1 month salary, direct the management, direct the tribunal to decide within 3 months. If they don't lead evidence, I will lead evidence over victimization is concerned. I can lead evidence before the tribunal like labor court on victimization. I will finish it off within 3 months. At least the suspension period, which has been prolonged beyond 3 months, that full salary may be directed to people. That's an equity which I am appealing to a lot.
Please repeat.
The order of suspension which has been passed, we will calculate and give the memo to the other side. Automatically lapses on expiry of 90 days in the Supreme Court judgment. This was continued for more than a year. Thereafter, it is followed by an order of dismissal. We are entitled for a salary of nearly 9 months full salary. This is the one, without causing an injury to the other side. I am appealing to lordships. Number 2, let the EAT directed to be disposed of the matter within 3 months. Now the pleadings are completed. The issues has to be framed and then the matter has to be posted for evidence.
3 months.
Now they already held an inquiry. And the short question would be, if the association officer goes to the principal chamber and raise an issue so far as the other professor is harassing another lady, it is a case where a woman being harassed. We went there and they issued a charge sheet, terminate us from services, and without a complaint of the principal available on the inquiry record. It goes to the very root of the matter. Where do they get power to frame a charge? Complaint. Complaint is not.
Now the matter, in case both of you want a finding on the correctness of the order, then we'll have to keep it pending. If it could be disposed of on some equitable, mutually acceptable terms, then you can dispose it of. It is your choice.
I don't want the matter should be kept pending because it would cause great prejudice to these 2 people. Because they have been out of employment. Both of them are in trouble and both of them are without any basic of food per each day. That's the position.
So now, Mr. Murthy, what is your stand? Can there be some? There are two. One, if you insist that matter is to be heard on merits, then we can keep it pending after considering what interim arrangement is to be made. But if there could be some equitable arrangement amongst both of you, then we can see what is to be done and then send it back.
But I won't appeal to your lordship. Yes, sir.
My lord, sir, one submission, my lord, after having heard my learned friend, I also fully agree with him that the matter should not be kept pending. Now, my lord, one or two legal points, that is also I will not touch upon now because I'm an unaided educational institution. Government permission is not required, but I'm not going into the merits of the matter. Now, my lord, if the court makes an equitable order, my lord, may I am not under instructions to submit this as a senior counsel. I'm making a suggestion whether the court could do this. Now, my learned friend says in 3 months it has to be completed. If that is so, if your lordship consider last drawn salary to be paid for 3 months, these 3 months as an interim measure and close the whole thing, the case itself will be over in 3 months. Thereafter, the final order will take care of the further requirements to be carried out in terms of the order. So if my learned friends' clients are in dire difficulty, if the court feels that it could make an equitable order, that for 3 months, let them be paid last drawn salary for these 3 months and quash the rest of the order. Lord, that may be an equitable order which your lordship may pass.
So now the amount that was directed to be paid to both of them as per the impugned order amounts to how much?
My lord, in the first case, it will be 3 lakhs up to date. In the first case, it will be 3 lakhs up to date.
In the first case, my lords, it would be 3 lakhs up to date.
In the second case, it will be till the date of return 4 lakh 15.
Date of retirement.
4 lakh 15.
In the second case, till date of retirement as ordered by this court, 50%, it will come to 4 lakhs 15,000. 3 lakhs in the case of Mr. Parameshwar, 4 lakhs 15,000 in case of Guru Brahma, who has already retired.
Roughly 7 lakhs between both of them.
Yes.
Now, can we say 25% and then fix? Can we say 25% and fix without reference to the
by sheer coincidence, I was talking to my colleague, Mr. Somshekhar. I was telling whether 25% would be all right, and the court immediately echoed it as though the court heard what I am talking. 25% court may pass an order, my lord. As a court order saying 3 months or 6 months, whatever it is. 25% of the amount be paid till completion of the case. That is lump sum 25%.
Wrong approach. And then that friend is now repeating 25% in future.
25% of that sum.
I only submit 9 months salaries over the suspension beyond 3 months. There cannot be any grievance on that aspect.
How much that comes to?
9 months salary.
How much that comes to?
9 months salary.
9 months salary will arise only if I don't issue a charge sheet within 3 months. That rule does not apply here. But if my learned friend wants to go by law, then my lords, where is the question of compromise?
No, we are not on that question. How much roughly, according to you?
The court has now, out of the order that the court has already passed, I will be required to pay 3 lakhs to Parameshwar and 4 lakhs 15,000 to the other, that is to Guru Brahma. Now, out of that, I said, if the court, I also thought court has that in mind, 25% to be paid, even without asking the client. I may say, your lordship may pass a court order. Beyond that, I'll have to go back to the client.
So now 3 lakhs and 4 lakhs, according to the impugned order. Now we take it as 25% of 3 lakhs and 25% of 4 lakhs. then fix a time and then send it.
No, the 3 lakhs and 4 lakhs is 50%.
That is what the court has ordered.
Figures which my learned friend has given is 50% of what has been granted by the tribunal.
No. What is the tribunal granted? Whatever it has granted, 25% of that we will ask them to pay, and then fix the time limit and finish it and close the matter without entering into the merits. Shall I pass it over at 2:30? You can just think about it and come back. 2:30, just think about it. We will say 25% of this 7 lakhs, if that is the calculation, and put an end to it and fix a time limit for expeditious disposal without entering into the merits. So within 3 months, 4 months, what some reasonable time will fix it, and 2:30.
They are seeking one additional increment for a cost of the Kannada language exam. According to the representation of the order, my lord, order, my lord, they are seeking one additional increment. According to their made a representation to the respondent of that. That representation has not been considered.
AG accepts notice for the respondent. Look into it. List the matter week after next. Yes.
You engage the service of the senior counsel. All 3 matters kindly Tuesday.
Made on behalf of the petitioner. List the matter next week. Yes. Yes.
WP 10-212-202 of
Just one minute. Yes.
And petitioner while working as assistant engineer, not a penalty of withholding 4 annual increments with cumulative effect was not imposed.
All of them are in BBM.
Identical matter.
Yes.
The penalty of withholding 4 increments with cumulative effect was imposed. But he approached this honorable court challenging the said order on the ground that he has not been communicated with the report of the inquiry and the procedural lapses in conducting the inquiry. Based on that, an interim order of stay was granted. Last may kindly see the interim order that was granted at page
10202. You are referring to. You are referring to writ petition 10202.
Yes, ma'am.
Anybody for the BBMP is there? BBMP. Yes.
The interim order that was granted by this court is at page 58, my lord.
Yes.
But the last may kindly come to page 59, my lord. Now, Shri Vijay Kumar, learned counsel for the petitioner, has submitted before imposing the penalty as per the interim order at annexure J. The district authority has not served this local notice along with the report submitted by the local actor. And the interim order passed by the respondent number 1 is violative of principles of natural justice and contrary to KCS 957. Hence, he has sought for stay of annexure J. In view of the above, there shall be an interim order of stay of the interim order by annexure J, dated 2/2/2022. But based on this, Lord, I had submitted a representation before the DPC, stating that my claim be considered for promotion. Under identical circumstances, my lord, this honorable court has also granted interim orders. My lord, your lordship may kindly come to page 62, my lord.
So what's happened to the inquiry now?
But inquiry, after conclusion of the inquiry, penalty has been imposed.
Yes.
But when the penalty was imposed, they have not followed the procedure prescribed under the CCA rules by furnishing the second show cause notice as well as the report of the inquiry. They have straight away proceeded to impose the penalty. Therefore, my lord, I approached this honorable court and this honorable court has stayed the proceedings. In the meantime, my lord, the DPC was held to consider my claim for promotion. Lord, I submitted a representation enclosing a copy of the interim order stating that there is a stay of the penalty order, therefore seal cover need not be applied and I may be granted promotion. Under identical circumstances, Lord, several persons have also approached this honorable court and have obtained a stay order. In the stay order, there was an observation that the claim for promotion shall also be considered. Since in this interim order, such an observation was not there, Lord, the DPC has proceeded to apply the seal cover. Whereas the person who have obtained interim order with such observation, they have been granted promotion subject to result of the request. In this petition now, my lord, I am challenging the observation made by the DPC, my lord, and my lord, I have sought for stay. With the direction, my lord, let them consider my claim for promotion, my lord, to the higher post. But in terms of the orders that have already been passed in respect of identity cases,
now we will ask one of them to take notice, and we'll have it, and then we'll close the matter. At least we'll pass an interim order in their presence. Let us see what they have to say. Now, according to you, the other persons with similar interim orders.
Yes, ma'am. I have produced the DPC, my lord, in which their claim has been considered. Your lordship, see that. Page 73, my lord.
Correct. Shall pass an order. In their presence, we'll pass that order.
Based on the interim order granted, my lord, the DPC has considered their claim only on the ground that there is a direction, observation of this honorable court to consider their claim for promotion. Whereas in my case, the interim order is silent about it, and therefore my claim is not being considered.
We have it on Tuesday. In their presence, we'll pass the interim order. We'll see what they have to say, and then you appear for BBMP. Learned Council, Shri so and so, accepts notice for the second respondent. PG accepts notice for the first respondent. Consideration of interim prayer in all these matters are kept open. The second respondent to take the stand regarding the same by the next date. List the matter on Tuesday. No? Tuesday. Yes.
Even my case also, it's a fresh matters, but interim order has to be considered.
So correct, interim order, I will consider, we'll hear the BBMP and I'll pass orders. Now they have, the effect of the interim order will be to permit them, I mean, for them to take note of the, in the DPC without reference to this inquiry. That is the relief that you have sought for.
Yes.
In their presence, I'll pass an order. Now you are pointing out that similarly placed.
Copy has already been served on them. They have not appeared, my lord.
It is.
The amount of public service, and if so much public service is concerned, the education has to be done by the appointing not by the government. However, it's so much higher than the investment order has been passed by the government. All subsequent orders are void. But this I'm here out of this honorable court. This honorable court, the division which is following the department inquiry so far as BJP employees are concerned. Following which, my lord, the senior of this court on case against directing the BJP not only staying your department inquiry, but also considering the case for promotion. But we are also one of the similarly placed as the other petitions.
That I have produced at page 62, my lord. Page 62. Page 62, my lord.
But they are only seeking similar relief passed by the coordinator.
Lord, can you see, Lord, the impugned order dated 37/2018 passed by the first respondent by annexure A is stayed till the next date of.
So read the whole order.
Yes, ma'am. Order in IA number 1. Third, the learned counsel for the parties in IA number 1 of 22. The learned counsel for the petitioner submits that the impute order of penalty has been imposed by the government by order dated 37/2018 by annexation A. Since the petitioner is a B group employee of the corporation, the disciplinary authority is the commissioner and the state government has no power to pass the impute order. In support of his contention, he submits that the division bench of this court in writ appeal number so and so has granted an interim order in similar circumstances. In view of the above, IA number 1 of 22 is allowed. The impute order dated 37/2018 passed by the first respondent by annexure A is stayed till the next date of hearing. The respondents are directed to consider the case of the petitioner for promotion if he is otherwise eligible in accordance with law. This last sentence is the one, my lord, which is not available in my interim order, and therefore, my lord, they have not considered. In all these cases, that is the issue. That's all.
That is the same.
Yes.
You have a copy of the writ appeal order? No, you are on the same footing as the others. That they have not challenged that order.
Which will not disorder the part. One point, clarify your lordship. Page 95 may kindly receive.
Yes.
The order passed on 18th August, not in the writ appeal number 64 of 2021. Passed by the nation at the service. That is similar to page 97 is the red post. We permitted to read. The right counsel for the appellant Townsend has argued before this court that the appellant was an employee serving in DVP and certainly not a government servant. Therefore, the imposition of penalty when audited its source so equal to 4 annual inputs to the effect is added up into the judgment ever by according to the court. Okay, so I was whenever I was the court clearly got the opposite. This court has clearly got the opposite. However, the 7 and the opposite judgment. It has a judge. What emerges from the opposite discussion is that Karnataka local act requires public servant as well as government servant. Operating authority and state act for public servant as reminded 212G is a state law. Under the CCA rules, the expression government servant is defined as definition. Authority is issued to impose of penalty. On a government servant is authority competent and rules to impose on it that penalty. But the said rules do not apply to public servants as defined under section 2 of good voting of the CCA rules, investment of the employee to look at only investment of public service, government service, not public service. In the absence of there being such a provision for investment, the state government cannot enter such an employee to look at as the case will be under the said rules. But the state government is also not the disciplinary authority in respect of such officer. State government of the system import from local must submit the state particular seal of rules of the areas of public service employee. The disciplinary authority can then enter the employee to local enter. If the good voting and CCA rules have been adopted in the scale of the particular and in the scale of rules can specifically provide prescribe the investment of the employee to local in case of either of the state cannot accept the jurisdiction and the good voting of the CCA rules to invest the employee to local. Therefore, having regard to the opposite element of the provisions for all entities which are excluded the rules of CCA rules, the requirement of provision of good voting and CCA rules with respect to scale of the sort of voting of that would avoid litigation regarding to which deserves investment of employee to local. The reason for CCA rules are in the 1990s. That is Karnataka local authorities of 98. Good voting of CCA was inserted on the enforcement of Karnataka local authority. All similar to good voting incorporated explicitly or adopted by legislative. This is finding by the keeping in view the opposition as the imposition of penalty recommended by local has been able to make prima facie case that result in the operation of the product
So in all these matters, the entrustment is by the government.
Yes.
Page?
Page 14. Similar to the Millard portion at page 21. The investment order has been by the government, urban development department, not very commercial area. All of it is the individual charter, what is capacity, country model. Is it the single unit? As also consider for promotion. Now, what has happened in the meanwhile? The orders were to approach this on during the vacation period. BBC must have done it. And certain people who had very little consider for promotion, they have been granted promotion. So far as we are concerned, still no procedure has been followed. We are entitled for promotion because there is no specific direction. So far as this honorable court is concerned, to consider for promotion, we have been kept under safeguard. Now we are seeking to stay of the inquiry. As also we are considering calculation for promotion. And this can be single case.
Just the interim order that you pointed out is at page?
That is at interim order is at page. Here also, my lord, the entrustment is made by the first respondent.
So the stay, even in that matter, is of the order of entrustment.
Yes. Page 18. Order is at page 86. If protection is granted pursuant to division bench in the number scores between these what will the APP is the page? As a little bit is going to stay on this part and again the additional personal issues of articles of the what has happened is I had approached earlier, my lord, challenging the penalty order and the interest. This honorable court granted an interim order stay at page 58. But where only the stay was granted, my lord, but there was no observation regarding considering my claim for promotion. Therefore, my lord, I filed a representation before the DPC.
In your matter, there is already a stay of the department.
There is a stay of the inquiry proceedings. But my lord, since there is no specific observation that I am entitled for promotion, but my claim has been considered under seal cover.
All these matters, the petitioners. So then shall we pass separate order in your matter? In your matter, which one that is?
That is a 10/02 of 22.
The others, 30.4, we can pass a common order.
30.4 is 10/308 of 22.
Correct. That we can pass a common order.
Yes. There also there is an interim order of stay of further proceedings in the inquiry.
Okay, so 30.1 and 30.4 separate order. 30.1 and 30.4 separate order will pass.
Yes.
Yes. Other matters. In serial number 30, 30.2 and 30.3. In all these matters, petitioners have challenged the validity of the departmental inquiry initiated. Correct. So I have taken up your matters now. Have a challenge the validity of the departmental inquiry. No, I'm on 30, 30.2 and 30.3 for the present. The contention of the petitioners is that the entrustment under 14A of the CCA rules is by the government, and the petitioners and the disciplinary authority insofar as the petitioners are concerned, being the BBMP, entrustment could not have been made by the government. Reliance is placed on the judgment of the division bench in the WA 634 of 2021, where where the division bench of this court by order dated 18th August 21, while observing that the government has no power to make entrustment insofar as the disciplinary authority for the employees of the BBMP should take necessary action, has granted an interim relief whereby the operation of the operation of the order of entrustment has been stayed, and order of entrustment as well as proceedings consequent to which have been stayed. Taking note of the order in WA 634 of 2021 and also interim orders passed as regards similarly placed employees. You also produce page.
Taking note of the order in WA 634 of 21 and also interim orders passed as regards similarly placed employees.
In WP 2780, there would be an interim order in the present matter also. The respondent number also the order of entrustment at annexure D1 in 10097. You go one by one. In 10097, it is D1. Look at your interim prayer. No. Look at your interim prayer. You said D1. No. So what is the interim relief now? So now your entrustment is C. There would be an interim order stay of annexure C and consequent proceedings. The respondents are at liberty to move for modification of the order if grounds are so made out upon filing of statement of objections. It is clarified that the respondent number 2 is to consider case of the petitioners for promotion. Case of the petitioners for promotion in light of the interim order granted. Now we have stayed it, so now we have asked them, so that would be the effect, isn't it? So what is it? So it has to be last in the video.
The corresponding is to consider the case of petition for promotion in the light of the interim order.
By opening the seal cover, all orders that may be passed in favor of the petitioners, needless to state, are subject to final orders to be passed in the writ petition. Now, the same interim order in 10097, 10249, same annexure. And in 10258. Same annexure, same order. So ಇದು ಮೂರು same order. The office objections to be complied with in WP 10258 of 2022 in adalli. Next IA 1 of 22 1024. In WP 10249, petitioner filed IA 1 of 22 seeking for dispensation of production of certified copies of annexure C and D1. In light of the undertaking that the same would be produced in due course, IA is allowed and the petitioner is dispensed with production of certified copy of annexure C and D1 for the present. Now come to your matter. ಅಲ್ಲಿ notice ಬಂದಿದೆಯಲ್ಲ, council Arvind M. Neglur accepts notice for the respondent BBMP. AGA accepts notice for the other respondents. Copies to be served on the respondents forthwith. Yes, in your matter.
My case also, my lord, the first matter, my lord, the investment is made by the first respondent and I had approved this on the report. There was an interim order of stay.
10202.
Yes, sir. But that interim order of stay, my lord, I had submitted the representation to the DPC. My lord, DPC has applied seal cover on the ground that there is no specific observation made by the court regarding grant of promotion. Therefore, my lord, I had challenged the DPC proceedings itself. And my lord, I have sought for an interim order, my lord, directing the DPC to consider my claim.
But then that's the main relief, isn't it?
Yes, the interim relief is to consider my claim for promotion by opening the seal cover. As there is already an interim order of stay in the inquiry proceeding.
The main relief is only to consider it by removing the seal cover.
Yes, sir.
You could have sought for in that writ petition only, isn't it?
Yes, my lord, but then what happens is there is a specific, there is a separate cause of action that has occurred, my lord, in lieu of not granting me the benefit which was already granted to other similarly placed persons.
So then we can allow this writ petition. That's the only relief he is seeking. There's already a stay of the departmental proceeding. Now he is only saying that in light of the stay of the departmental proceedings, consider it, and that consideration will be subject to final orders passed in the earlier report.
Yes. And in that case, my lord, let there be an interim order, my lord. Let them file objections, my lord.
We are only saying, of course, you will have to get back.
Let them open the seal cover and grant me promotion, making it subject to result of this writ petition.
But then the interim prayer and the final prayer is one and the same.
No, it is connected with the another writ petition, my lord. Therefore, my submission, my lord, that in view of the interim order already granted in the writ petition, my lord, the benefit of opening the seal cover and granting me promotion will be considered, my lord.
Currently, annexure M, my lord, DPC.
Correct.
That is because, my lord, they have not considered my claim, though there is an interim order.
Only on the ground that the stay order has not mentioned liberty to take note of it. Once the departmental inquiry stayed, then you have to consider it. Yes. And whatever consideration is subject to the outcome of the petition. Annexure A. What is M?
And that DPC proceedings, my lord, they specifically say that in view of there being no interim order, last time I kindly see.
Correct. Now, forget about the annexure M. We are only going to say that you have to consider the case for promotion in light of the stay of the departmental proceeding. That's all. Validity of the DPC, will leave it at that. They are not going to ask for any rights vis-a-vis other private respondents. They are only going to ask for relief of considering their promotion because of stay of.
Let that not be considered now. Let them be a consideration only to not grant promotion by opening the seal cover.
No, that he will withdraw that. He will clarify that.
Yes.
He will withdraw that prayer.
And DPC only insofar as the petitioner is concerned, my lord. I'm not challenging the entire DPC proceedings, sir. Kindly see the prayer, my lord.
Otherwise, you ask the senior to come, you find out, take inspection. Only on this aspect. We are not going to pass any order on merits. What we are only going to say is in the earlier petition, there is a stay of the departmental inquiry. So now we will only say that the respondents to open the sealed cover consider their case for promotion. If otherwise they are eligible, whatever is happening. That consideration will be subject to final orders to be passed in the earlier report. That's all. Find out and come back at 3:30.
No, my lord. In that case, let the order be passed, my lord. Let the interim order be passed to that effect, my lord. That is not going to affect any private persons, my lord, because what I have challenged is only the DPC proceeding insofar as the petitioner is concerned. But kindly see, my lord, I have made out a prima facie case, my lord, and I have served a copy.
The only point is the interim prayer and final prayer is one and the same.
Yes, my lord, let that be modified, my lord, to the extent that I am entitled only to open the seal cover, and then grant promotion, making it subject to result of the petition.
Grant an interim prayer.
Yes.
Finally, will be. I'll have it on Tuesday.
Please.
And insofar the final prayer, make a.
Yes.
The petitioner in WP 10202 submits that he had challenged the validity of the departmental inquiry in writ petition.
Petition number, my lord, 3875, my lord, of 22.
Page, where is the order?
Page 58.
I challenge the validity of the proceedings, departmental proceedings in WP.
Penalty has been imposed. That penalty is imposed with the an interestment being made by the first respondent, that is government, which is without authority as held in the division bench order.
2 years promotion also, madam.
That has been stayed.
I challenge the validity of the departmental proceedings culminating in imposition of penalty in WP 3875 of 2022. Considering the various contentions, this court by order dated 21st February 22 had granted an interim stay of the order imposing penalty.
Yes.
Dated 2/2/2022. It is submitted that the said interim order is in force as on date. In the light of the same. Next, it is contended that despite such interim order, the respondent authorities in the DPC proceedings have failed to take note of the interim relief granted to the petitioner and have resorted to sealed cover procedure. Next. It is further pointed out that similarly placed employees were granted interim relief as per the order dated 23/2/2022 passed in WP 36865 of 2018, whereby the petitioners in the said case, whereby the respondents were directed to consider the case of the petitioner for promotion, taking note of the contention raised and also noticing the interim order of stay of the order dated 2/2/2022, which remains in force. The respondents are directed to consider the case for promotion of the petitioner without resorting to the sealed cover procedure. Such consideration would be
Since we have
subject
already resorted to sealed cover, let there be a direction to open the sealed cover.
to consider the case of promotion by opening the sealed cover. Needless to state, orders to be made by the respondent would be subject to final orders. It is submitted by counsel for the petitioner that the main matter could be itself disposed of as he is enjoying an interim order in the other writ petition. Accordingly, list the matter in the orders list on Wednesday. It's only on that point. So in the earlier proceeding, the departmental inquiry is stayed. Whatever final order is passed will be passed. Whatever promotion by opening the seat cover interim order we have done could be subject to orders to be found. So which is the other matter?
Same, my lord, that is 10/308 of 22.
Same order or any?
Granted. Same. Interim order.
Correct. There must be some change, isn't it?
Change is that the interim order is granted in a separate writ petition, my lord, that is 3244 of 22, page 247.
So usually same order. No? Now the interim order passed in WP number.
WP number 3244 of 22, my lord.
3244 of
22.
2022. On?
That is on now. That's on 14/3/22, my lord, page 249, my lord. Here I had my lord, I had challenged the very initiation of the inquiry, my lord, on the ground that the competent authority has not passed the order.
Interim order passed in WP 2244 of 2022 on 14/3/2022. Baki Jamhur. Same order. Yes. WP at seal number 30, 30.2 and 30.3 to be delinked and listed separately. Yes. On 30.1 ನಲ್ಲಿ ಕೊಡಿ IA. ಇದು BBMP government advocate ಅದೆಲ್ಲ ಸೇಮ್. Except what is for BBMP, the government advocate. 30.1 IA 1 of 22 has been filed seeking dispensation of production of a certified copy of annexure M in light of the undertaking that same would be produced within a period of 4 weeks. IA is allowed petitioners dispense with production of certified copy of annexure M. It is 30.1 only. 30.4. Petitioner has filed A1 of 22 for dispensing with the production of the certified copy of the proceedings at the next week for the same order. ಆಮೇಲೆ IA2 of 22 also same order. IA2 of 22 also you undertake to produce, isn't it? Same order. Yes. Yeah, ಎಲ್ಲದರಲ್ಲೂ same. DDMT ಗೆ ಅವರು government. Yes.
May it please your lordships. I have concluded my arguments, my lord. The respondents have to, my lord, the answer. And in the meantime, my lord, lordships had orally observed thrice that they should consider the solatium to be paid, which is, my lord, a no-fault liability, which so far has been not paid. I have 4 children, my lord, and I have nothing, no sustenance. And the respondents, my lord, are completely oblivion to, my lord, my needs. At least, my lord, the solatium amount, which is, my lord, stipulated in the KPTCL's own circular, may order to be paid, or else they can go ahead with the matter, my lord.
First respondent.
Where is the other respondent?
This one Patma Utturi is appearing.
And one more aspect, my lord, I'm sorry. One more aspect, lordship said observed on the last occasion that they should find out whose lines are these, who owns these lines which have caused this electrical accident. Amongst them, they have to discuss and come back, my lord, to the honorable court as to who is responsible for the accident, whose ownership the transmission lines lie.
If I may conclude my side, whether
Welcome. The next part, welcome. So now, some interim relief you pay, the rest you will see.
may make so far as that. Here, so far as that, rightly, so far as that 11 kVA which has been incident happened. Where, that the second respondent is maintaining so far as that line is concerned. That the first respondent, that so far as the KPTCL is concerned. That so far as the second respondent, Patma Utturi is appearing. On account of that her mother admitted hospital sick for time, today has been posted. That's the comeback today evening. She wanted to learn the Monday may be accomplished. But there is that the liability has to be learned that the KPTCL or the SESCO has to be learned that where the find out so far as the line which is the so far as the accident occurred.
ಅದನ್ನ ಇಷ್ಟು ದಿನ ಆದ್ರೂ ಇವ್ರು ಲೈನ್ ಯಾರ್ದು ಅಂತ ಇನ್ನೂ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
ಅವರೇ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ. But in the absence of the second responder, I don't want so far as that make allegation.
We extend the matter to Friday only for this purpose.
This is that she said plus that today plus that her mother is discharging from hospital. She will come back today evening. That she said that Monday plus that she accomplished. She sick but still Monday.
Second matter, are you ready?
Monday.
Second matter.
Second matter also plus because the first elected they decide this matter plus already hard.
ಅದೆಲ್ಲ ಯಾಕೆ?
No, all matters are similar.
But in the second matter, they have paid the solatium, I am told, my lord. I inquired, but that
by kindly fix Monday 2:30 minutes that I will
also needs to be heard.
In the presence of the second respondent in the first matter. Monday 2:30.
No, let him conclude his arguments in my matter, my lord.
Now we'll do one thing. Monday is not possible, Tuesday is not possible. Next Friday, top of the list, first matter.
Friday, the difficulty that Friday EB matters only one day, Friday. Before that, any date plus my kind of before that.
We'll have it at 2:30 on top of the list on Tuesday. We'll conclude.
31st, my lord. 31st.
One by one, we'll take and say. Because then there will be difficulty. I don't want to reserve it. Open court only will dictate. Settled position.
Position of law, there are just 2-3 additional arguments that I had. My lord, deems it fit, I will make this. I won't take more than 15-20 minutes as far as the legal propositions are concerned. On facts and ideas, because the victims in this are children. One of them is a 7-year-old child. There is a sense of urgency, my lord, insofar as the treatment that has to be taken place insofar as these kids are concerned. In half an hour, I would imagine, my lord, on facts and law, I'll get.
The second matter is concerned like interview compensation already paid.
That's there. Now, but you have placed whatever expenditure you have incurred on record. We directed last time.
I filed in both matters.
You filed or you filed?
Yes, I've already filed them.
Yes.
Not yet.
There will be a copy on it. So, but we'll start with the first matter at 2:30. One by one, we'll discuss.
On the law, my lord,
what is the additional submission?
One is, my lord, even so far as understanding the entire legal terrain as it stands at this juncture. The Electricity Act, my lord, of 2005 is what occupies the field. And the rules that have been made under the 2005 Act and the regulations that have been made under the 2005 Act, those are what hold the field. But repeatedly what we find, my lord, in the objections, that the 1956 rules keep going back. Whereas 1956 rules are not in operation. In fact, my lord, these are that is one proposition that I want to just clarify, my lord, exactly what is the legal framework that covers this particular case.
Yes.
The second aspect, my lord, that I want
so you come back to the first one.
Please.
So what is their contention?
My lord, when the objections that have been filed in my matter.
Yes. So this will have a bearing even in the first matter, isn't it?
I may also have to make submissions. I don't have the benefit of objections filed. I'll collect it from Clifton. I will make submissions on this aspect as well.
In petition number 6087 of 2019.
087.
Para number 8, my lord. Para number 8. What they would say is, it is respectfully submitted that Rule 80 of the
just one minute. Yes.
Respondent number 2, my lord, here is the KBTCL.
Yes.
This is their statement of objections at para 8. It is respectfully submitted that Rule 80 of the Indian Electricity
No, just one statement of objections
of the second respondent. Respondent number 2.
Yes.
Para number 8.
Yes.
It is respectfully submitted that Rule 80 of the Indian Electricity Rules 1956 prescribes certain distance which has to be maintained between high voltage lines from a building. But my humble submission is that these rules are not even in force at this juncture. Lord, please see the Electricity Act of 2003.
Yes.
This Indian Electricity Rule which is referred to, my lord, that is under the Indian Electricity Act of 1910.
Yes.
The Electricity Act of 2000, Section 185 will please be seen.
Section
185. This is the repeal and savings clause. Specifically, my lord, 185(2)(c). The Indian Electricity Rules 1956
made under Section 37 of the Indian Electricity Act 1910 as its before such to be shall continue to be in force till the regulations under Section 53 of the Act has been made. Lord, may please see the regulations that have been made.
The rules of 1956 will be enforced till the new rules are there.
Till the regulations under Section 53 are framed. The regulations have been framed in 2010. It is the Central Electricity Authority. Measures relating to safety and electric supply, regulations 2010.
What are the regulations called?
Central Electricity Authority, brackets, measures relating to safety and electric supply, close.
Measures relating to
safety and electric supply, close brackets, regulations 2010. Pass it on, my lord.
Regulations 2010. So this is in force as of now.
Yes, my lord. These regulations, my lord, right at the top.
From 2010 onwards.
Yes.
These are in exercise of the powers under Section 177 of the Electricity Act, right at the top. Under the notification. Lord has got the notification.
Under 177.
My lord may please see now 177. Section 177. Section 177 2B. Section 177 2B would be suitable measures relating to safety and electric supply under Section 53.
It goes back to 53.
So now that these regulations have been brought into force, it's not tenable, my lord, that the rules of 1956 are being relied upon. The Allahabad High Court, my lord, had an occasion to consider these provisions. So the relevant provisions, I will just point out the regulations which are relevant, my lord. I will not trouble them. Regulation number 5 of these 2010 regulations. Regulation number 5. Which mandates, my lord, an electrical safety officer shall be appointed all suppliers of electricity, including generating companies, transmission companies, and distribution companies, shall designate an electrical safety officer for ensuring observance of safety measures specified under these regulations in their organization for construction, operation, and maintenance of power stations, substations, transmissions, and distribution lines. But from the construction all the way to maintenance, the entire onus, my lord, is on the authorities.
On the ESCOMs.
The generating companies, transmission companies, and distribution companies. So that covers KPTCL, it covers all the distribution companies, including BESCOM, ESCOM, so on and so on.
The electrical safety office.
Please. And it specifically says, my lord, for ensuring observance of safety measures specified under these regulations. Regulation 12(1), my lord, is also relevant. All electric supply lines and apparatus shall be of sufficient rating for power, insulation, and estimated fault current, and of sufficient mechanical strength for the duty cycle which they be required to perform under the environmental conditions, and shall be constructed, installed, protected, worked, and maintained in such a manner as to ensure safety of human beings, animal, and property. In a sense, my lord, these regulations, they imbibe the spirit of MC Mehta, my lord, the absolute liability spirit. My lord, may also please see regulations 58, which is the clearance above the ground for the lowest conductor of overhead lines. So it is not Rule 80 now, my lord, that occupies the field. It is these mandates. Please, my lord, regulation 58. And it's for different volts, my lord. 650 volts, then for 11 kV. My lord, may please see 58.3. That is for 11 kV, which is my lord, the line which electrocuted Chandana, my lord, the girl. And for the, if I can read 3, my lord, no conductor of an overhead line, including service lines erected elsewhere than along or across any street, shall be at a height less than, for lines of voltage up to and including 11 kV, 4.6 meters. That's the clearance, my lord, from the ground that is required for every 11 kV wire, which is what we find on every road. 66 kV, of course, my lord, those are the high transmission. And for that, they have appropriate. My lord, may also see regulation 60. This is for clearances from buildings. Yes. 68.2.1, my lord, would say. When it passes above a building, a vertical clearance of 2.5 meters from the highest point, and when it passes adjacent, a horizontal clearance of 1.2 meters. But unfortunately, this, my lord, is not something that is being done. There is enough number of cases where the wires pass just at the side of balconies. And regulation 61, my lord, is also relevant insofar as clearances for buildings. My lord, may please see regulation 63 now. My lord. Yes. If at any time subsequent to the erection of an overhead line, whether covered with insulating material or not, any person proposes to erect a new building or structure of flood bank or to raise the road level or carry out any type of work, whether permanent or temporary, or to make in or upon a building any structure of flood bank, and so on. So he and the contractor who he employs to carry out the erection, the erection, addition or alteration, shall give an intimation in writing of his intention to do so to the supplier or the owner and the electrical inspector, and shall furnish therewith a scale drawing showing the proposed building, structure, flood bank, road, or any additional alteration and scaffolding thereof required during the construction. So what this contemplates, my lord, if there are already wires, whether high tension wires or low tension wires, written permission should be secured. My lord, the implementation of this, my lord would recall, is with the safety officer. It cannot be said, my lord, that people are building wires in any erecting constructions in any which way and our hands are tied. The law provides, my lord, for what can be done in such kind of circumstances.
Safety officers appointed or no?
That's for the respondent to inspector.
Not electrical inspector. Electrical safety officer under that 2010 regulation number 5. Find out if the electrical inspector is the same officers under regulation 5 or somebody else. Just find out.
My lord, so far as this is insofar as the regulation itself is concerned, my
So
lord.
the enforcement of all this, including putting up a building, etc., is the electrical safety officer.
Yes, my lord, because the electrical safety officer is tasked with a very important job to ensure that the safety regulations are complied with, from the construction up to the maintenance of every single wire.
So the application to include the builder doesn't cannot be at their
It's not
instance.
even arise, my lord.
It cannot be at their instance. Yes.
My lord, and so far as the act is concerned, I've already referred to section 53. I'll only point out 4 provisions, my lord, just for noting. Section 68 is also of relevance.
68
of the Act, Electricity Act of 2000. So that's relevant to overhead lines.
Yes.
An overhead line shall, with prior approval of the appropriate government, be installed and kept installed above ground in accordance with the provisions of subsection 2. The provisions contained in subsection 1 shall not apply in relation to electric line which has a nominal voltage not exceeding 11 kV and is used to supply to a single consumer in relation to so such of an electric line as is or will be within premises in the occupation or control of the person responsible for its installation or in such other cases as prescribed. So the prior approval. Every single line, my lord, can only be with a prior approval, and its continuance presupposes that there is a permission. Subsection 3, my lord. The appropriate government shall, while granting approval under subsection 1, impose such conditions as appear to it be necessary.
At the time of laying the overhead line
and keeping it up,
the government should grant permission.
Please, madam.
So at the, obviously permission must be granted, keeping in mind the requirements under these regulations.
Please, madam. That is what it presupposes.
If anything comes up after that, then it's for the electrical safety officer to ensure compliance with the.
Section 146, my lord, provides for the punishment for non-compliance with the orders and directions and the regulations. And that, my lord, the punishment is a jail term of up to 3 months.
In case somebody violates.
Please, my lord. Previously, my lord, in the 1956 rules, in fact, I think it was some 100 rupees or something, my lord, the punishment. What rule 80 was referred to, the penalty for violating that was just a nominal amount. Now, my lord, may please see what is in 146.
So the direction under 146 can be by the government, can be by the electrical safety officer.
Please. Whoever fails to comply with any order or direction given under this act, within such time as may be as specified in the said order or direction, or contravenes or attempts or abets the contravention of any of the provisions of this act, my lord, may please note here, or any rules or regulations be thereunder. Any contravention of the regulations, that's how it would be read, shall be punishable with the imprisonment for a term which may extend to 3 months or with fine which may extend to 1 lakh rupees, or with both in respect of each offence, and in case of continuing failure, with an additional fine which may extend to 5,000 rupees for every day during which the failure continues after conviction of the first such offence, provided that nothing shall apply to 121. 121 is the appellate authority's orders. So violation of the regulations, this is the punishment that the statute contemplates, my lord. It's imprisonment or a fine of up to 1 lakh rupees, my lord, which is quite a stringent punishment for the violation just of a regulations. Well, so the legal framework, my lord, this is the legal framework within which my humble submission is, my lord, that the liability of the state will have to be assessed.
Sir, on this point, can I make 1 minute submission? Once my learned friend completes.
Which is the judgment you're saying, Allahabad High Court?
Please, my lord, I will come.
I think this
Prabhu referred to my memo, my lord.
must have yes.
Says that from page 95, it's a division bench order, my lord, of the Allahabad High Court. My lord, may please see page 98 onwards. The judgment starts at page 85.
Yes.
Starts at page 95, my lord. Relevant pages, the relevant pages starts from 98, para 10 onwards.
Yes.
Please, my lord. From para 10 onwards, my lord, judicial notice is taken on the various provisions of the Act. Section 53, 68, 160. And then, my lord, let me see the conclusion at para 70. That's at page 104. 104. Indian Electricity Rules 1956 provides safety measures required to be observed for supply of electricity. Unfortunately, my lord, I don't think that the 2010 regulations were brought to the notice. Thereafter, my lord, it is statutory duty of the person responsible for the supply and maintenance to abide by all the protective measures, since it is a dangerous commodity. The respondents corporation have failed to protect the life of the general public, and thus this case falls within the ambit of strict liability. There is a flagrant violation of the Act and rules by the respondents by not providing any safeguards, checks and balance to prevent escape of energy, which caused electrocution in the instant case, causing 100% disability to kids. The Lord may please also see page para 27, page 105. It again, my lord, they are bound by the Act and
what remains is only the quantification.
So far as quantification also, my lord, there are two submissions I have. In so far as the absolute liability is concerned, my lord, I realized I hadn't played NC Mehta on record, my lord. I just my lord, in the decision of the managing director ESCOM has taken note of this. It's there in the judgment that my lord has passed. In this, my lord, the relevant paras are 31 to 33.
31?
31 to 33. My lord. This is, my lord, the evolution of jurisprudence from the principle and license nature to absolute liability. The difference between the two, my lord, is very clear. Starkly revealed. My lord, if I just point out to two portions of this over the page, my lord. Para 31 over the page. In the middle of the first para, my lord, we are of the view. In the middle of that paragraph, the last 5 words are, we are of the view that an enterprise.
Yes.
We are of the view that an enterprise which is engaged in hazardous or inherently dangerous industry, which poses a potential threat to the health and safety of the persons working in the factory and residing in the surrounding areas, owes an absolute and non-delegatable duty to the community to ensure that no harm results to anyone on account of the hazardous or inherently dangerous nature of the activity which is to be undertaken. Lord, please note these two aspects: absolute and non-delegate. It's not something that you can shrug your shoulders up. You cannot say that it is not my responsibility, it's somebody else's responsibility. So when we talk of absolute liability, my lord, that's what the spirit is, that it's something that cannot be delegated. You cannot blame something else. My lord, the next paragraph.
No, the only other question,
please.
They were making some submission that no doubt they will have to bear, there's no doubt about it. Whether they could reserve right to recover, like principle of pay and recover.
Yes, my lord, that there are enough judgments, my lord, on that. In fact, even in Bhagya Bai's case, my lord, which my lord has already relied on that, when the matter was taken in to the Honorable Supreme Court, the Honorable Supreme Court, my lord, has given them liberty that you please recover it from the person who you feel is guilty. There is no problem in that. It's in my memo of citation, page 22.
Page
22 of my memo of citation. The order of the Honorable Supreme.
Just take me to the relevant.
Yes, my lord. Page 23. We further direct that the petitioner shall be free to seek such redress as may be permissible in law against the so and so, the alleged joint tortfeasor. Page 23.
This that liberty is granted. But after here also the SLP was dismissed. Supreme Court refused to interfere with the order, but the reserved liberty. Petitioner shall be free to petitioner was the DESCOM. DESCOM was the petitioner before the apex court. Petitioner is at liberty to seek redress in law against so and so alleged tortfeasor. Yes.
As far as absolute liability is concerned, my lord, I'm relying upon NC Mehta. I'll only give, my lord, the paragraph numbers of 4 other judgments. Madhya Pradesh Electricity Board versus Shail Kumari, That, my lord, is the first judgment in my memo of citation. Para 7 to 13, my lord.
Para?
7 to 13. Here again, my lord, the act of a stranger, etc., all of those defenses have been checked.
Only strict liability without defense. Yes.
Next judgment, my lord, I'm relying upon is HSCD versus and others versus Ramnath. That's the third judgment in my memo of citation. Same proposition, para 6.
Yes.
Page 7, my lord. Para 6. The appellants are carrying on a business which is inherently dangerous. If a person were to come into contact with the high-tension wire, is bound to receive serious injury and die. As they are carrying on to the business which is inherently dangerous, the appellants would have to ensure that no injury results from their activities. If they find that unauthorized constructions have been put up close to the wires, it is their duty to ensure that the construction is not demolished by moving the appropriate authorities, and if necessary, by moving a court of law. Otherwise, they would take the consequence of their inaction. There are complaints that there are wires that these wires are dropping and almost touching the houses. They have to ensure that the required distance is kept between the houses and the wires, even though the houses may be unauthorized. In this case, we don't have complete responsibility on them. The third judgment, my lord, that I'm relying upon, insofar as this proposition is concerned, is Bhagya Bhai's case. The Honorable High Court's order, my lord, is from page 8 onwards. And the relevant paras, my lord, are 3 and 7. Para 7 is sufficient, my lord. Shail Kumari is relied upon. Page 14, my lord. Of course, the decision of my lords which was rendered in Dharwad, in that paras 32 to 34. The flag, my lord, is for the ease of reference. 34. The lord is also relied upon Mehta and Bhagya Bhai.
Yes.
This is one proposition. Only two more propositions I have. In these two writ petitions where I am representing the petitioners, both of them are children. My humble submission is this: when we are talking about children, there is an added duty on the state to ensure the safety of children. They cannot come, my lord, to this honorable court saying that the child is negligent. It's a child, my lord. The doctrine of parents patria comes into play, my lord, but the state is duty bound to ensure that the health and safety of the child is protected. Those are constitutional obligations. Articles 39F and Article 45, for instance. There is another aspect, my lord, in this. This, my lord, has been ratified by India, my lord, and it is in place. The lord may please see Article 3, what is known as the best interest principle. At page 3, my lord. In all actions concerning children, whether undertaken by public or private social welfare institutions, courts of law, administrative authorities, or legislative bodies, the best interest of the child shall be the primary consideration. Article 6, my lord, is what is the right to life of the child. State parties recognize that every child has an inherent right to life. State parties shall ensure to the maximum extent possible the survival and development of the child. My lord, insofar as disabled children, my lord, it is Article 23. I'm only relying on one judgment, my lord, insofar as this proposition is concerned. Honorable Supreme Court, my lord, in NCPCR versus Rajesh Kumar, 2020, volume 11, SCC 377. Para 2, my lord. Para 2. India is a signatory to the United Nations Convention on Rights of the Child 1989, which makes it obligatory upon the state signatory states to take all necessary steps to protect the rights of child as set out in the convention. So at least when it's the case of children, my lord, should not lay in the out of the state, my lord, that these kinds of defenses should not be taken. That is my humble submission. My lord, may please see para 15 so far as the recommendations of the Child Rights Commission is concerned. In all of these cases, my lord, in both the matters that I am representing, the Child Rights Commission has passed orders that 50 lakh compensation should be given. Very unfortunately, my lord, those orders were challenged by the state, my lord. And an order was passed that it should be considered as a recommendation. This is BESCOM's challenge, my lord, in our matter. My lord, would please see internal page 7.
This is order passed in.
This, my lord, the BESCOM challenged the recommendation of the Child Rights Commission in our matter, where the Child Rights Commission had directed that 50 lakhs compensation should be given. That recommendation was challenged by the state. At para 7, what the court held was, thus from a perusal of the aforesaid provisions, it is evident that the state government is required to take an action on the recommendations which will be made by the commission. In the absence of any specific provision in the Act empowering the Commission to issue an order directing payment of compensation, and in the fact situation of the case, I deem it appropriate to direct that the order passed by the Commission shall be treated as a recommendation. This, my lord, is what this Honorable Court held. The Lord may please see what the Honorable Supreme Court has held at para 15. Para 15, my lord. Any commission, while conducting an inquiry under section 13(1)(G), has been given wide powers akin to that of a civil court, and has a right to forward any case to a magistrate, and the magistrate is required to deal with such case forwarded to him as if the case had been forwarded to him under section 346 of the CRPC. The follow-up action which a commission can do is also clearly set out in section 15 of the CPCR. That's the Commission for Protections of Child Rights Act, which empowers the commission to make recommendations to the concerned government or authority for initiative of proceedings, including prosecution or any such action as the commission may deem fit. Please note, my lord, this is a recommendatory power, but normally what we would expect that the government would accept the recommendations of the commissions in this regard. Now, having considered the entire facts and circumstances of these two cases, my lord, in both matters, the Child Rights Commission has made recommendations for a certain amount of compensation. My humble submission, my lord, in light of this decision of the Honorable, the respondents must at least pay that much of compensation to them.
Recommendation is the Child Rights
Commission. Please, my lord. In both matters where I am representing. But in another matter also, the Honorable.
We are saying this is a subsequent order. We have to have a relook at the order in the writ petition in terms of the Supreme Court order.
Yes. Because this is on 13/1/2020. 13/1/2020. And the order of our High Court, my lord, is 38/2019. In order to pose a question as to whether action can be taken against the person supposedly responsible. In a different matter, my lord, where there was a death of a person falling into a sewer, a similar order was passed by the police. Not only one last proposition so far as the quantum of compensation. There are only three decisions to rely upon. One is, of course, the recommendations of the Child Rights Commission in both matters where I am representing. Also relying upon, my lord, the decision of the Apex Court in Raman versus Uttar Haryana Bijli Vitran Nigam Limited. It's at page 81 of my memo, my lord.
Yes.
In this, my lord, the compensation that was accorded was 60 lakhs, my lord. The manner in which it was accorded was, my lord, is at para 19. 19. 19. Page 91. In view of the law laid down by this court in the above proposed referred cases, which are extensively covered and granted just and reasonable compensation. In our considered view, the compensation awarded at 60 lakhs, the judgment of the learned single judge of the High Court, out of which 30 lakhs were to be deposited. And what has got it, madam? Page 91.
Page
91. This is in Raman's case.
Yes.
Bottom of the page, my lord, para 19.
Yes.
In view of the law laid down by this court in the above referred cases, which are extensively considered and granted just and reasonable compensation. In our considered view, the compensation awarded at rupees 60 lakhs in the judgment of the learned single judge of the High Court, out of which 30 lakhs were to be deposited jointly in the name of the appellant, represented by his parents as natural guardian, and chief engineer or his nominee representing the respondent Nigam, the nationalized bank in a fixed discharge till he attains the age of majority, is just and proper. So 60 lakhs, my lord, was the compensation that the Honorable Supreme Court upheld in that case. Of course, my lord, now it's in Naval Kumar's case. And my learned friend would have probably taken my lords in detail through that judgment of the Himachal Pradesh High Court. In that, my lord, the compensation that was given was 90 lakhs. The Supreme Court decision is at page 72, my lord. Not the PC, the relevant para is para 15 and 17. My lord. Para 15 is at page 77.
Left to right.
I will take 2 minutes after.
Yes.
Lordships are taking it up on 31st, my lord.
On 31st. Release the matter on top of the list at 230 and 31st.
Yes.
Matter 32 ನಲ್ಲಿ Malad in serial number 32. I have filed my statement of objection. Other contesting respondents have not filed. Whether they are ready or not, I don't know.
Date may continue to be party as I am for the petitioner. I party as the senior service of senior court. The date may kindly be fixed in the next week for us. Date, any date.
Readings are completed. Please. Then who appeared?
In my case, my lordship, Mr. Puttagoda is appearing.
I have filed my statement of objection.
Let us see. I list the matter in the week commencing from 20th of June.
Obliged.
Serial number? Yes. Have you informed the other side? 49. Date for this 2011 month. 9. Already adjournment has been taken. On that day we see. We'll see.
Not serial number 33, my lord.
Yes.
There are two matters listed under serial number 33, my lord. The first matter, my lord, senior panel counsel Ariga is appearing, my lord. And that objections has to be filed on behalf of respondent number 1, my lord.
Let us see at 2:30. We'll see at 2:30.
Serial number 35, both counsels present. I want to file objections to the petition and for respondent's institution. There's 2 weeks time in the matter.
The request made on behalf of the respondent.
Serial number 35.
Who submits that statement of objections will be filed. This is the matter week after next. List the matter. Let us list the matter in the week commencing from 20th of June. Yes. Yes. The counsel for the let us at request of land counsel for the respondent. They list the matter on 2nd
Court officer? Court officer?
Court officer. Sir, serial number 50 adjourn ಆಗಿಲ್ಲ ಅಲ್ಲ? Serial number 50. Sir? Okay, sir.
Sir, serial number 39. 39. Okay, sir.
Sir, serial number 45, sir. Sir, serial number 45 ಇದೆಯಾ sir?
Court officer.
We'll just wait, let the other side come. We'll just wait for 5 minutes, let the other side come. Yes. Varidhara Nodi on this. Can just, Somsekhar, can you just see if he's there? If otherwise you have to go there and come, then we can, we'll take it up as soon as it comes. Password. I've just passed over.
Your Lordship, indicate 25% from the date of the application till the disposal of the main matter.
Date of?
From the date of the application. Here from the date of termination 2019. 25%, Your Lordship.
So then we will say 25% of 25% of
the last drawn wages, that is measured from the date of termination 17/9/2009 till the disposal of the main appeal. Instead of 50%, Your Lordship would indicate 25%. So far as the suspension is concerned, my lord, in fact, I have examined. There is no prior approval. There is a decision on this aspect of the matter. In fact, that question may be decided before.
So 25% of the last drawn wages.
From the date of
termination.
Till the disposal of the main appeal. And
that is which writ petition?
First petition. 25% is date of disposal of the appeal on the last drawn wages. Similarly, the date of
10,323 he has already superannuated.
Just
January.
So this order will be in 10,305.
Correct.
Yes.
In 323, 10,323, he has already superannuated in January 2022. It could be restricted to that time.
25% of last drawn wages from date of termination till date of superannuation. And then we send back the matter back to be disposed of expeditiously. Because now it's only on the IA, on the interim review.
But I would only appeal to your lordship some time frame. But though
expeditiously ಅಂತ ಹೇಳೋದು ನೋಡೋಣ. Anyhow, they will continue to pay, isn't it? In the first matter, 25%. So then, so we'll see expeditiously. I'll say because we don't know what is their workload.
that is our lord. The workload may not be known, but if your lordship could indicate some outer limit.
How much time they take these appeals?
6 months.
I don't know how the appeal comes. So 6 months is a reasonable time. 6 months is a
appeal
reason.
is already filed, my lord, in 2019 itself.
19. So we can say 6 months.
Depending upon the requirements,
The WP 10305 of 2022 has been filed by the management calling in question the validity of the order dated 22/4/2022 passed in MA EAT 19 of 2019. Thereby, the tribunal has allowed the application seeking interim relief. Matter was heard for some time. Both the learned senior counsel are appearing for the respective parties. Submit that an order may be asked by consent without entering into the merits of the contentions raised while keeping it open to be agitated at an appropriate time. Taking note of the scope of the present petition being limited to challenge of the order passed granting interim relief. The following order by consent is being passed. The appellant to pay the respondent 25% of the last drawn wage from the date of termination till disposal of the main appeal. Petition is disposed of in light of the above arrangement being made, which addresses the grievance of the parties. Contentions of the parties are kept open. Appeal to be disposed of within the tribunal to endeavor to dispose of the appeal within a period not later than 6 months. That is. Then next same order except for from date of termination till date of superannuation. Next same order last drawn wages from date of termination till date of superannuation. Date of superannuation in January 2022. Yes.
This consent, this arrangement by consent is applicable till the final disposal. Because in the event of the applications are being allowed, let them not take up this.
The order by consent is limited to the present proceedings only.
Please.
Now, one clarification from both, since both of you are there. Now, this service matters, one difficulty for a judge who suddenly comes to this roster is in one matter you pass some order and then you realize the consequence of it. So in some matters in the vacation bench, the orders passed saying though you were supposed to retire, you don't relieve him. Now, of course, that's a matter to be decided, but I feel that such matters we may have to pass at least after hearing the other side. Suppose you pass an ex parte order, the full gamut of the implication of increasing in effect from 60 to 62, we are not aware, isn't it? But
in fact, I was there, my lord. In fact, I also obtained a similar order. Your lordships passed an order based on the earlier orders.
No, where
vacation
bench I didn't pass.
Where there is already an interim order, the Advocate General moved the matter. In fact, in one batch of Agriculture University, the learned Singh dismissed the petition on the ground that the UGC is not applicable to the Agriculture University. Though they are getting the central fund taken up in appeal, that's a different matter. But in all these such cases where one university revised, extended the benefit of age of superannuation for 65 years under the Karnataka State University, on the principle of parity, the matter was heard and orders were made absolute interim order. That's it.
Okay, so what I'm saying, suppose the discrimination is contended. Now the court may strike it down. But how are we going to say that we increase it to, that is the government should, isn't it? So suppose some action is shown that the employees of two different, one is aided and one is government, they have to be treated on parity.
That question is concluded by the Supreme Court in a judgment delivered on 21/3/2020. They said the same benefit shall be 21/3/2022. Sorry, 21/4. Just one day after the closure of. I'll pass on with that. But yesterday the appeals were there and it is listed to be on Monday in Dharwad.
So I am passing orders last today. I said relieving, if any, will be subject to final order. That's what I stated. I didn't grant a stay. But then if it is so, then let the matters be decided the earliest. Why keep it, isn't it?
Yes, but one Vishnu traders case by the apex court said once there is an entry order in one case, if the facts are similarity, the 95 SCC supplement 1 SCC page 456. It's a very 10 lines order. If there is a similarity, one entry order it has to. You will ask me fix a date, but of course, the division bench yesterday indicated that the matters are to be heard very. So first hearing, the matter is listed on Monday. After notice to.
Same question is being heard.
Same question. And the relieving is taken place on 31st. So therefore, the matters are listed on 30.
So division bench also is carrying that same government order.
What happens if there is an age of superannuation prescribed by the UGC regulation? The regulation 1.1 itself says it prevails over under Article 246 over the state legislation. But the present Chief Justice of India in Kalyani's case says, if your lordship may remember, this education after 42nd amendment, earlier it was a state subject under entry level. After 42nd, this education has been removed and included as a item 25 in the concurrent list. Both state and the center has got jurisdiction.
so far as this education is concerned. If there is a law made by the state legislature, that has to yield a place to the central legislature. So UGC made a regulation under the UGC Act. And my Lord Justice Chandrachud Jay, my Lord, in 2018, 17 SCC 456, para 10 and 11, said that any regulation framed by the UGC in the interest of the nation will have a minimum standard for the whole of the nation. Whole of the nation. So there are two things, my Lord. Minimum standards is also comes under entry 66 of list 1 of 7th schedule. Then 25 list, the entry says any law made by either by the union or by the state is subject to entry 66 of higher education. So therefore, right from 1963, Malad Gujarat Hindi case, it has been consistently laid down that the UGC regulation will prevail over the state legislation. If there is a conflict, if there is no conflict, absolutely there is no difficulty at all. Now, after the 7th Pay Commission, where the 7th Pay Commission recommended both the pay scales and the age of retirement is a uniform throughout the country. Then the HRD ministry accepted 7th Pay Commission. Then UGC said, till I frame the regulation, you follow the 2017 zero. Then the regulations have been framed. In the regulation, they indicated 2.0. Any superannuation and the pay scales issued from the Union of India, Government of India, from time to time would apply by the UGC. So there is a change method in the language of regulation. So the age of superannuation, so far as the state level, then there is a direction also. Each state or the university should amend its law within 6 months. Until the amendment, these regulations will occupy. Of course, Justice Devdas took a different opinion, and though his lordship said the UGC regulations apply to the state government, state university, but it also applies only to central university. Then the whole entire university in India and people who are presently getting the UGC skills are being affected.
But will the same logic hold good to aided and government?
Yes,
no, but UGC and state government is one part. What you are saying?
No, the coverage of the UGC regulation is for all the university established under the Central Act, provincial, the State Act, and all universities established under the state legislature. Now we are going by the Karnataka State Universities Act of 2000, earlier 70s. Under the various universities like Cluster University, Maharani's Cluster University, where there is an interim order, it was made absolute. And Mangalore University, Bangalore University, Gulbarga University, and Karnataka University. These are all universities governed under the one act called Karnataka State Universities Act. And if for one university, if you extend 65, the argument was when the very same university comes under the Karnataka State University Act, you can't differentiate within the university. But UGC regulations applies deemed university buildings. And the Directorate of Collegiate Education, that is the first word. In 18, they have included collegiate education. So any universities established under the state legislation, central, provincial, any colleges affiliated under any university, and it prevails over any other state law. And the moment 18/7/2018 regulations have been published, it says it is deemed to occupy the law wherever it is vacant, nebulous status. And each regulatory authority should amend it within 6 months in conformity with these regulations. That's the position. And there is a Nice judgment, my lord, by Justice M.R. Shah and my lord Justice Nagaratna Jay on 3/3/2022, my lord. I'll pass on the charge judgments, your lordship. I made a compilation, my lord, the government circulars and the relevant government order. I'll pass on to the court master tomorrow, so that this UGC regulation will occupy. Whether the state legislation would adopt it or not, it makes no difference. But the Supreme Court says it applies to the centrally funded institutions and universities. But if the state wishes to adopt it, then it becomes mandatory. It has no option to alter. And now the government has adopted it and getting 80% of the pay scale from the central government. And they are only sharing 20%. If they don't adopt it, that's a different matter. The degrees conferred by these universities would not be recognized by the UGC because under section 22 of the UGC Act, whether it's a medical, veterinary, any university, unless and until those degrees is included under section 22 of the UGC Act, no university will confer degree. And these regulations applies to medical, veterinary, agriculture. It says, it prevails under Article 246 over any other legislation. That's the position.
So the aided institutions which are admitted to grant in aid, and if they seek parity with respect to retirement with government employees, same logic according to you will hold good.
That is the judgment dated 21/4/2020.
Right?
By the Supreme Court. I will give the judgment. That is exactly the question. That is exactly the question.
Just give it to the court of.
Please. Your Lordship, fix a date, any date. Of course, there are number of cases where I am appealing. I took an interim order from your Lordship's in the vacation. More than 4 or 5 matters. There is also other 10 matters. And meanwhile, the judgment of the Lordship Justice Devdas would be considered by the division bench.
When is that matter listed?
Monday it is there for interim order. Of course, yesterday it was there. I appeared. Monday, my lord, I was asked to be there physically. I'll report your Lordship's at least. And tomorrow I'll leave the court master. I made a government orders and important judgments. That in the Tamil Nadu matter and various the dental council of India, it has been laid down by Justice Chandrachud Jain 2018, 17 SC, 426. All judgments have been analyzed. He said that wherever there is a UGC regulation, that is a coordination, entry 66, a law made by the union legislation, law made by the state legislation, to the extent of inconsistency, the state legislation is void and inoperative. Whether the state government brings up an amendment or not, 6 months is one parameter. But regulation 1.1 Roman 1 says, till you amend the law, this law will occupy that state. That's the position. And AICT regulation, my Lord Justice Nagaprasanna Jay has already rendered a judgment, it is 65 years. And the matter went in appeal, but there is no interim order. And one more judgment was delivered by my Lord Justice Krishna Kumar Jay, that 65 is not applicable. This question has been dealt by the Lordship Justice Devdas and referred the matter. And reference was, of course, I should not comment. When appeals are pending, the matters can be posted along with the writ appeals. But reference, while making a reference, that the judge has committed a judicial impropriety was totally unnecessary. It's my personal opinion.
32. Ashwini Radhikapur.
Okay.
The respondent number 1 is connected matter.
Mention was made at 2:30.
Yes, my lord. Senior panel counsel Hariga is not well, my lord, so he is not questioned to appear today. So, short adjournment, my lord.
Next week.
First matter, my lord. The first matter.
When do you want? When do you want?
First matter is related to a promotion issue, my lord.
No, this is 32, is it?
33, my lord. 33, my lord. 33.1.
No, all these 33.1 and 33 both have to be disposed of together.
33.1 can be heard separately, my lord, because it is related to a disciplinary inquiry which is pending in the department. The serial number 33, my lord, pertains to a promotion related issue, my lord, where the petitioner has appeared in an exam and the exam result has been kept in a sealed cover because there is no clearance from the vigilance department. So there he has questioned the keeping the result in the sealed cover. The petitioner wanted to get the result declared so that he want the promotion benefits. He is seeking promotion benefits in the first petition.
They initiated the inquiry of the school class. I challenged the secondary petition after superannuation. That has been done before 4 years on the data superannuation. Issue happened from 2011 to 13. He retired in August 2019. It was filed in the next year. So therefore, beyond 4 years, there is not any inquiry.
Then we'll have it next week. At the request made on behalf of the respondent. This is the matter. We have it on 9. On 9. The same.
Matter can be heard finally, my lord.
This is. Use the mic. Who is the answering respondent?
I'm appearing to both the respondents.
You are answering respondent.
Yes.
Instructions are complete.
We find our objections.
What is the relief you have sought for?
The promotion is pending, my lords. Since there is a criminal proceedings pending, my lords. And the similarly placed other members of the employees, my lord, have been promoted, my lords. I have produced the promotion list and the seniority list.
So they've kept it in abeyance.
Please, my lords.
They've kept it in abeyance till the conclusion of the
Criminal case, my lords. I have filed a representation, my lord, just to consider the same, my lords.
What is your stand?
His contention is that similarly placed employees, their suspension period has been regularized. But our submission is that even though he has been firstly, criminal proceedings have been initiated against him and a departmental inquiry. But in the departmental inquiry, he's been exonerated. But the order of the department in the departmental inquiry clearly states that this is subject to the criminal proceeding. Your regularization of your suspension is subject to the criminal proceeding. So as regards other similarly placed employees that he is relying on, in those cases, those employees have not, no sanction has been given to them. No sanction for prosecution by the government has been given to them. So the other similarly placed employees cannot be compared with the petitioner here.
Well, so far as that observation, that the regularization of suspension is subject to the outcome of the criminal proceedings. You challenge that. Now you have been exonerated. That there is no, but that they are saying there's some observation.
But observation has been subjected to all the employees for whom the 26 employees, my lord, against whom the permanent inquiry was conducted. The subject was for all these 26, my lord. The subject can be produced, my lord.
Then first you take.
Page number 56, my lord.
No, you just take me to the observation. Let us have a look.
56, my lord.
Yes.
Adesh and suggestion, so my lord, dated 2nd February 2019.
No, just go to that observation.
This is observation, my lord. Second para, my lord. ವ್ಯವಸ್ಥಾಪಕ ನಿರ್ದೇಶಕರು ದೇವಿ ಪ್ರಾಣಿನಿ ಹಾಗೂ ಶಿಷ್ಟ ಪ್ರಾಧಿಕಾರಿಗಳು ನಾನು ಈ ಕೆಳಗಂಟ 26 ಅಧಿಕಾರಿಗಳ ನೌಕರರುಗಳ ವಿರುದ್ಧ ಮಾಡಲಾಗಿರುವ ಆರೋಪಗಳಿಂದ ಮುಕ್ತಾಯಗೊಳಿಸುತ್ತೇನೆ. ಸದರಿಯವರುಗಳು ಅಮಾನತು ಅವಧಿಯನ್ನು ಕ್ರಿಮಿನಲ್ ಪ್ರಕರಣದ ತೀರ್ಪಕ್ಕೆ ಒಳಪಡಿಸಿರುತ್ತಾರೆ.
Now you were arrested, is it? Were you arrested?
And among these who 26, my lord?
No, now the order only says period of suspension is dependent on the final outcome of the criminal proceeding. What was the period of suspension? How much?
He was suspended on 5/10. Tell you the exact. 5/15/2010 he was suspended, and his suspension has not been lifted. It's not been listed in all the seniority lists that have been published subsequently. His name has been next to his name. It says in field cover. I produced those also. You could just have a look at them.
No, it's only the period of suspension that is subject to the outcome of the criminal proceeding. He has not been reinstated at all.
No, he's not been
reinstated. He is working, my lord.
He has been reinstated. It's only the period of suspension.
Correct. You're right, your lord. He's been reinstated. His period of suspension has not been regularized.
Correct. So now that may be 5 months, 6 months, 8 months, whatever it is. That only that period is subject to the outcome of the criminal proceeding, isn't it? Then what is the, now you have not been promoted.
Promotion.
Now what has that got to do with his promotion? Now in case he's been exonerated, period of suspension, let's say, is 1 year. That will count into so far as his service is concerned. After his exoneration, it is the period of suspension is only whatever period that will have some financial implication outcome. Why should it come in the way of his promotion? Considering.
I understand what you're saying, your lordship, but although he's continuing to work, I don't think he's been reinstated.
How can it be continued if he's not reinstated?
That's usually.
No. How can that be done?
Let me seek instructions on this, your lordship.
Now what we are saying, that is promotion you consider. This 6 months or 1 year, whatever period of suspension, that we'll see what happens in the criminal. Now you find out. Now you also apply your mind whether that clause, that last part, you want to challenge, you think about it. Otherwise, challenge it. The court will decide whether such a rider can be placed in an order. You will consider the legality of it. Think about it. Now you find out. Now, when do you want it?
Have it after 2 weeks.
No. Now his colleagues, the other 26 persons who have been subject to the same condition, have been promoted, is what we say.
Have been the promotion list, my lord. Can you produce, my lord?
The other 26 have been told. That's the submission is making. Find out. If the other 26 persons who were part of, at least some of them, who are part of the same order have been promoted, then on parity you must extend the same.
Your Lordship, the others who were promoted have also produced file noting in respect of that. They have been promoted because no criminal sanction was given, no sanction was given prior to prosecution. I produced the file noting in Annex R1.
Okay, beholds that you remove his period of suspension and then you submit as to whether he is otherwise eligible for promotion. If he is otherwise eligible, then this may have to be ignored because this speaks only regarding the period of suspension and now he is working.
Kindly give me 2 weeks. I have to take instructions.
15 is the matter. 150. You find out. Yes.
So appointed as assistant layman.
I appear for the respondents in all the 3 cases. 37, serial number 37.
Yes. Pleadings are complete.
Pleadings are completed.
I have submitted a synopsis which covers all the 3 cases on hand, Your Lordship.
Division bench has issued the order. In fact, the appointment of the inquiry officer by the division bench itself. What we say, you give the same file to the inquiry officer appointed by the division bench. Mr. Shivagowda was removed and Mr. Engineer Sam was appointed.
If I may be permitted to briefly explain the facts of this case, Your Lordship, very briefly.
In my case,
I'll come to you. Let us see. How much time both of you will take?
I will take not more than 10 minutes, Your Lordship.
I think I'm also 10 minutes along with my friend.
Synopsis is filed.
Matter is very simple, Your Lordship. It's a simple matter. Who should conduct the inquiry? Whether it is the inquiry officer appointed by BESCOM or an inquiry officer appointed by MESCOM. This is all the issue before this, and it is already decided by a coordinate bench of this honorable court. And the issue is in a very narrow compass, Your Lordship.
Okay, let us see what you have. You represent the authority. You represent the authority.
I represent the respondents, Your Lordship. MESCOM, yes.
Okay, let us see what is your stand.
The MESCOM himself appointed this gentleman as the inquiry officer. I produced a copy of the notice and judgment.
May I explain the background, Your Lordship? It will be very,
yes,
it will make the clear. Your Lordship, this basically MESCOM, BESCOM and all these ESCOMs, way back in 2015, appointed 628 persons as assistant linemen. There was a notification, etc. and all that. And then 628 persons were appointed. Out of them, a large number of them, it was found that they had produced fake mask cards to get this appointment. And 74 cases out of that were reported. Out of the totally, there were more than 300 cases. Only 74 cases they received reports of having produced the fake mask card. And BESCOM and MESCOM, what they did was, without holding inquiry, they terminated the employment of these assistant linemen. All of them came before this, many of them came before this honorable court. And this honorable court decided that, held that without inquiry, they cannot be terminated. And that was challenged in 2 different writ appeals, Your Lordship. Basically, this is where the issue starts. There were 2 writ appeals, one pertaining to assistant lineman terminated from BESCOM, that is writ appeal number 260 for 2020, and another
260?
261, 261 2020.
BESCOM.
Yes, Your Lordship, BESCOM. That was held on 21/2021. And there was another writ appeal, number 144 of 2020. This was decided on, I'm sorry, writ appeal 261 was decided on 9/11/2020. I'm sorry, Your Lordship. And writ appeal 144 of 2020 pertaining to MESCOM was decided on 21/1/2021. Now, in this writ appeal 261 of 2020 pertaining to BESCOM, considering the large number of assistant linemen who have to be subjected to inquiry, the division bench thought that instead of holding individual inquiries, it is better to appoint one inquiry officer, and therefore directed that Sri H.M. Nanjundaswamy, retired district, be appointed as an inquiry officer, as far as BESCOM employees are concerned. Now, the same bench in writ appeal 144 of 2020 pertaining to MESCOM employees did not give any such direction. It simply said that MESCOM can hold inquiry. So this is the difference, Your Lordship, between MESCOM employees and BESCOM employees. BESCOM employees were subjected to one common inquiry, phase one common inquiry officer, whereas MESCOM was permitted to hold inquiry individually because the number of cases in MESCOM were much lesser. So accordingly, MESCOM initiated the inquiry. And in fact, another two writ petitions also supports my contention. That is writ petition number 5811 of 2021, and also this honorable court directed me to hold inquiry in terms of writ appeal 144 of 2020. Now coming to writ petitions 439, Your Lordship, that is the current writ petition. Here also the same order was passed by this honorable court in the previous writ petition, wherein I was directed to hold inquiry against this current petitioner, and the inquiry officer was appointed. At that time, they have come before this honorable court again challenging the appointment of the inquiry officer, saying that there is one more writ appeal in which there was no such direction that a common inquiry, that individual inquiry can be conducted by MESCOM, and therefore I have to be, inquiry has to be conducted by the common inquiry officer. That is all the issue that is before Your Lordship.
So now, what is it? Is it going to be difficult to have a common inquiry officer?
The only issue is that your MESCOM is pertaining to Mangalore and that area. The inquiry officer appointed for BESCOM is holding inquiry in Bangalore. So probably this was what weighed in the mind of the honorable division bench when it said that you can hold your inquiry without there was no direction to subject them to the inquiry officer appointed for BESCOM.
If the same inquiry, I'm just thinking, I'm not expressing a definitive opinion, but if the same inquiry officer is also ready to come to Mangalore and do the MESCOM cases, then you can think about it and end this ambiguity completely.
We are open to it, Your Lordship, because now what has happened is on this basis, they have also obtained a stay order, and these assistant linemen have been reinstated for so many years that they have now come to the stage of promotion.
Problem will be by them.
So no, just 1 minute. Now, if the same inquiry officer is ready to come to Mangalore at your expense and do it, there ends the dispute.
We are open to it. We have.
Then you find out. Then you find out and you come back. Now, in the event there is some difficulty, you think of a common person for both, unless now has the inquiry started in BESCOM? Started.
Yes, sir, I have produced a copy of the inquiry officer notice along with
okay,
the
now you find out. Now you find out, insofar as BESCOM is concerned, if he is ready to come and do it there, then some arrangement could be worked out there, and it's the problem.
Because the
I'll
number.
have it.
Please,
I'll
please.
have it. I'll have it next week.
Please, Your Lordship.
Not next week, but after 2 weeks, not to station. Next week I will not be in station. 2
No,
weeks
not
later.
no, I will see. Let them first get back. Then I will accommodate. Now, suppose same inquiry officer is going to come there and it's the whole dispute. We'll see.
The problem is that this inquiry officer happens to be a retired district judge, Your Lordship. So I do not know on what basis we can request, because he was appointed on the direction of.
No, he is working as the director of the arbitration cases in Bangalore itself.
Now, then you find out. You find out from him. If he says it is not possible, then we.
In fact, I have produced the copy of those issued by them, the inquiry officer, court officer. Along with memo, I have produced the copy of the notice and judgment of the MESCOM judgment.
In fact,
I have produced it. I have already produced it along with the memo.
There are.
No, if he
is regarding MESCOM only. Swami.
No, if he's ready, if he's ready to do it, there ends the dispute. Let him.
He himself has issued notice. Can you see my notice copy when I produced it with the Nanjur Swami himself?
Even assuming that the inquiry is held by MESCOM, Your Lordship, if they are aggrieved by it, all the contentions are open for them to challenge the inquiry itself, whereas the inquiry itself is not being, allowed to be held. That is the problem, Your Lordship.
So now the simple solution is you ask Nanjun Swami if he is going to do it. There ends the matter.
That's one employee from MESCOM, my lords. He is appearing before the same inquiry officer.
You're at Bangalore or Mangalore?
Bangalore, my lords. I have produced one autocopy, my lords.
No, now, just 1 minute. Now, are all of you ready to, all the workmen? I mean, MESCOM, how many of them inquiries now due?
Around 150, my lords.
No, if all of you are ready to come to Bangalore in your own interest because you feel that you need common inquiry officer is what you are requesting. If you are all ready to come to Bangalore, then we will. Then he will ask him there ends the matter.
One employee from MESCOM, Mangalore, he is traveling to Bangalore, my lord, for inquiry, my lord.
Only 3 or 4 persons.
This is exactly the reason why probably the Honorable Division Bench directed that inquiry can be held by MESCOM itself.
No, correct. Now, if the inquiry officer inspires confidence, according to them, they have more confidence in a retired district judge. Then so be it. After all, you are. So you can ask. You can ask him, get his consent. We'll have it next week. Now, if the workman.
No, not next week, next Monday. That is on the 8th or 7th. 7th, kindly have it 7th.
All that we seek expeditious decision on this matter, Your Lordship, basically because now they have been on employment almost for 5 years after it was found that they have produced a fake marks card.
No, correct. Now, why do we enter into the merits? It's on a simple question whether this person can be the inquiry officer. In your case, there ends their apprehension. Now, they may be ready to come to Bangalore also. The petitioners may be ready to come to Bangalore also. If that is so, then something can be done. You find out if the inquiry officer is ready to come to Bangalore, no issues. If he says it's difficult for him to come to Bangalore, workmen are ready to come and appear before him in Bangalore, there ends the whole matter. Find out and you can get back.
We have it 7th.
Only one request, Your Lordship. Only one request, Your Lordship. The inquiry may be completed in a reasonable amount of time. Otherwise,
that may be done. No objection. Within 3 months, you can complete the inquiry.
That we'll see. You just first find out. Now, if the workmen are ready to come to Bangalore also, you find out, get his consent. Either Bangalore, ask him Bangalore. That will be best. So all of them can be subjected to the inquiry in Bangalore. You find out and you come back. Find out and you come back.
7th, you can have 7th.
We'll have it on. We'll have it on 8th. 8th.
The interim order can be continued, madam. 37(1) and 2, then interim order.
The interim order is continuing, Your Lordship, based on which they have been continuing.
Just on list the matter. List the matter in the orders list on 8th. The counsel for the respondent submits that he would get instructions as to whether the inquiry officer appointed pursuant to the direction in WA 261 of 2020 would also be open to act as an inquiry officer in case of workmen of MESCOM. On the short point, you find out.
Please.
Interim order will be continued in 37(1) and 2, madam.
Earlier granted is extended till the next date.
The next date. Order is till next date antive.
First petition, there is no interim order. Petition number 439.
439. Interim order in 439 of 2022 is to be continued till the next.
There is no interim order in my petition.
I think it is there.
No, the application petition number 6189 and
Connected petitions, there is interim order.
The interim order in WP 6189 of 21 and 7945 of 21 to be
7940
to be extended till the next date.
Let
us see, they are not started. Now, just to settle the matter, there is no point in haggling over who is the inquiry.
Please, Your Lord. Yes, Your Lord. Please.
Petitioner is ready to travel to Bangalore.
He is ready to come to Bangalore. So at least in so far as such of the workmen who are ready to come to Bangalore, there will be no issues.
Please.
Only if they are asking to come at Bangalore, there will be an issue. So you keep both options.
I'll find out from the inquiry officer also.
Both options. Both options.
Both
Now,
options.
in case of Bangalore, there is no issue.
No issue.
Whoever. Now, in the other petition, the petitioners are ready to come to Bangalore. Mr. Achar.
Yeah, Mr. Achar has to say that.
In the other, are you ready to come?
They are ready. There are hardly 4 or 5 persons are there in Bangalore, not more than 5, I think so. Out of 5,
no, but each one has to come to Bangalore.
No, that is correct. That is their lookout. Now you will come to, let them, if they, Mr. Achar, you are ready to come, your client is ready to come to Bangalore.
Mostly ready to come back to Bangalore.
Find out by then. Yes.
Please, okay. Please, Your Lordship.
Much obliged.
Much obliged.
Yesterday, I was taking my notes. So the defense statement I made before the inquiry officer, which is at annexure H, page 102. Notes, I said that banks reply to the Commissioner of Customs is annexed to this and marked in the inquiry but not relied upon. By the refused to be into the inquiry office. At page 109 is the bank's reply. There are no Para 2 at page 109 are the allegations contained in the customs notice. Page 109. This is the reply
dated 20th November 95. My lord should get the date at page 125.
Yes.
It bears two signatures. Signature is one is signature of the bank's advocate and another is of the bank. Who signs is not relevant for Syndicate Bank Nariman Point branch. It is signed by the Deputy General Manager of the branch of the bank. And this is in answer to a notice issued by the bank alleging the very same irregularities which they fashioned to me in my charge sheet in respect of the very same current accounts. My lord should get the details of the basis for the notice at paragraph 2, page 109.
I think this council is the same. He's a custom. I mean, he's a retired custom. That B.V. Kumar.
Yes, Mr.
He writes that book of some book he has written of all the investigations of customs.
No, not that. H.L. Kumar, who writes about the labor law and service. Most of his handbooks are there on labor law complaints. H.L. Kumar. This B.V. Kumar Malats, I am told he is specialized in.
He is a retired member of CGAT.
Yes, ma'am. Yes,
No, he writes a column
yes, ma'am.
in a newspaper wherein all these customs raids.
Yes, correct, ma'am.
It makes very interesting reading.
In fact, Malats, about his expertise in these matters, there cannot be any doubt. He has practiced for almost 40 years in this line. Then he has been the judicial member, the technical member of the.
I think he is a member of CGAT.
Yes, SAGAT member subsequently. And this SAGAT appellate forum, which the appellate body, which exonerated all of us, is headed by Justice Y.L. Bhatt. After his retirement as Chief Justice of the High Court of Madhya Pradesh, he was heading the SAGAT. And irrespective of what is the finding of the SAGAT, of course, in this case, it is in my favor. As I pointed out, my lords put it to me also that bank cannot take two stands, one here, one particularly here, when in respect to the same allegations. And just read these allegations, my lords, because yesterday I read to my lord the charge sheet issued to me. The accounts which are mentioned in this customs notice are the very same accounts. Syndicate Bank, Nariman Point Bank allowed the opening of current account number 2873 on 31/195, current account 2878 on 3295, current account 2882 on 8295, current account 2896 on 20th February 95, current account 2890 on 21/95, and current account 2899 on 21/95. All the above 6 account holders addresses have been found to be not existing at the declared places, as well as the introducing firms are also not existing at the addresses. 4 of these current accounts, namely 2873, 2878, 2882, 2896, have been utilized for deposition of amount approximately 4.37 crores in cash and for obtaining DD and pay orders immediately thereafter. Secretary Sen has admitted his role with respect to the opening of operation of these 6 accounts. The facts and circumstances discussed in A, B, C above the show cause notice clearly appear to show that Maulana Azad Road branch of Bombay Mercantile Cooperative Bank had permitted bank account transactions of 15.5 crores. That is not about the
Bombay Mercantile, that I will skip. Next one, para C. Syndicate Bank Nariman Point branch allowed opening and operation of these accounts on 31st January 95 and 21st February 95. These accounts were solely being operated by Zaki in an irregular manner. The account holding forms were fictitious. No verification was started by the bank about genuineness of the account holders. These accounts were being utilized for deposition of rupees 4 crores approximately in cash, and on a single day on 20th February 95, an amount of 1 crore 41 lakh 54,000 was deposited in cash and 5 transactions amongst others. The accounts were operated with bank officials without proper introduction. Cash amounts were being accepted in huge quantities on the day of the opening. Checks were being issued on the same day. The introduction of the account were from account holding funds, which were not holding or operating accounts in the same name of the same branch of the bank. The conduct of the operation of these accounts clearly appears to show that these accounts were operated in an irregular manner in total contravention of normal banking practices. This is the allegation. Syndicate Bank Nariman Point, Bombay, whether Molan BM Bombay Mercantile Cooperative Bank, Molan Azad Road, and Abdul Rahman Street branch have acted in a manner amounting to criminal act of abetment with the persons named at A above by opening accounts in their bank of the non-existing. All these things are there, Manoj. Same smuggling, used for smuggling and all that. Then, Manoj, the para 6 at page 113, Manoj.
Just a minute. Yes.
Para 3 at page 113. In the light of the above, the notices, that is Syndicate Bank Nariman Point amongst others, were called upon to show cause as to why penalty should not be imposed on them under the provisions of 112, 114, 117 Customs Act for offences relating to smuggling into India, gold valued at so and so. At the outset, this is the reply of the note, this is the statement of the bank. At the outset, notices are grateful to you for providing us an opportunity to inspect the documents relied upon by the department for the allegations made in the show cause notice and for permitting us to take copies of such documents.
This was not.
This was not done to me. Bank is grateful to customs for having done all this. For me, they say, you be grateful to us, we are not providing you documents. The notices would like to submit that. Syndicate Bank was set up in the year 1925, all those things, they are not relevant. The operative part of that defense is at para 9, page 114. Para 9, page 114. The notices emphatically state that they had no knowledge or reason to believe that the currency under seizure, which was seized from the premises of Syndicate Bank, Nariman Point branch, are the sale proceeds of smuggled goods. They would like to respectfully submit that at no stage, right from the stage at which the 6 current accounts were opened, the accounts are extracted. Till the date of seizure of the impugned currency and cleared, they were aware of or having knowledge of or reason to believe that the said currency was the sale proceeds of smuggled goods. The notices was further asked to show as to why penalties should not be imposed on them under section 112, 114 and 117 of the Customs Act for offences related to smuggling into India, gold valued at rupees 26 crores approximately, and smuggling out of India foreign exchange valued at 24.90 crores approximately, which includes the seized documents of so and so. Then Manoj, para 11 is not of much significance because it only extracts the provisions of law. Para 12, the notices would like to respectfully submit that they had no knowledge or reason to believe that gold valued at 26 crores approximately was smuggled into India by any of the account holders or for that matter any person mentioned in para 28 of the show cause notice. Further, the notices with reference to such alleged smuggling of gold into India have done or omitted to do any act which act of omission would render such goods liable to be confiscated under section 111D or abetted the doing of provision of such an act. Then, my lord, sir, it continues. My lord, may kindly come to paragraph 16. The notices would like to submit that they have not contravened the provisions of section 107 of the Customs Act, which was a careful, para 17, a careful and documentary evidence cited by the department in the show cause notice, then refer to the sections. Then, my lords, they also say at para 19 about the indicatory statement of Zakir, who was not examined in my inquiry. But this, if the investigation report and all that is looked into, it would definitely refer to all these things. Customs or customs or that is the reason I wanted opinion of Mr. B.V. Kumar rendered to the bank even before this reply was given. That is one of the documents I have sought. Because he would have dealt with the account opening of how it has been done and all that. Then, my lords, in the next paragraph, that is at page 19, my lords, at para 19, coming to the statements recorded in the provisions of section 108 of Customs Act. Paragraph 19. Coming to the statement recorded under the provisions of section 108 of the Customs Act, Zakir said, Rahmatullah, in his statements dated so and so, deposited that he opened 6 current accounts. He opened an account in the name of so and so and gave the name of proprietor of so and so. He further stated that he gave the name of Ramkumar Sharma as the proprietor of Chuksi and Co. Though the real proprietor was Sandhi. Regarding the other form of accounts, he does not know them closely, and hence he could not state as to what their real names are. And those persons were introduced by Ambala for the purpose of opening of account and for obtaining the order. He reasonably believes that the names shown in the bank accounts are not their real names. He also stated that the account holders have not deposited or withdrawn or accepted. They operated the said 6 current accounts and they were solely being operated by him for the purpose of depositing cash and for obtaining orders and withdrawal of cash. Next sentence is very, very crucial for me, my lord. However, he has not stated anything about involvement of notices or its employees in such activities. Then notes they deal with next paragraph, Sayyid Munawar's statement. First line itself they say.
So he was not examined.
They were not examined. Sayyid Munawar, in respect of his statement, also bank says, in his statements dated 21/2/95, 22/95 and 26/6/95 has not stated anything about the involvement of notices or its employees in such activities. Next paragraph, 21. Muhammad Rashid Ibrahim, in his statements dated so and so, has not stated anything about the involvement of the notice direct employees. Direct 22. Khan Intizam Murtara, in his statements dated so and so, has not stated anything about the involvement of notices or its employees in such activities. Then notice they go on in every paragraph, they say that There is nothing in the witness statements to implicate Syndicate Bank or its employees. Then finally, my lords.
No, but would the non-examination of these witnesses vitiate the inquiry?
That cannot vitiate the inquiry. I'm not saying that if the bank has, if the investigating of the bank, investigating officer, MW of the bank, has not either gone through or referred to their statements. Their examination may not be necessary. But if he has referred anywhere to their statements, or if he has referred anywhere to the customs notice in his report, then what happens is disclosure of those materials and witnesses from whom he gathered those informations, both will have to be made available. For the reason, my lords, for all that I am saying, bank's reply would be, principle, strict rules of evidence will not apply. Further, Supreme Court has answered even in the year 1969 in Central Bank of India versus Prakash Chand Jain, that no doubt the strict rules of evidence and provisions of Indian Evidence Act do not apply. But it is not tenable to say that principles of natural justice, which form part of the Evidence Act, would not apply in the Hellik Burudila. And one sentence there is, statement made outside the inquiry cannot be treated as evidence. Now what happens in this case? If the person from whom he gathered the information, that is the original informant, is examined, I can tell him, I can ask him an inquiry, a question in the inquiry. What you are saying is wrong. Where from you gathered this information? Here, what happens is, from what sources God alone knows, from what documents an investigating officer alone knows, he gathers some information. All of it is deposited in the inquiry as his evidence. I always tell my colleagues in my office, what is the difference between direct evidence and indirect evidence, and why investigating officer cannot be a substantial witness? No, my lords, what happened to Draupadi in Mahabharata, everybody knows. She was dragged to the Sabha and there she was humiliated. Vyasa is author of Mahabharata. If you cross-examine Vyasa on that, what answer Vyasa can say? He can only say, this is my story that is narrated to me by so and so. If you want to cross-examine anybody, or if you want to examine somebody as a witness, it must be the real original player, Dushasana, not Vyasa. They bring Vyasa to inquiry. And at least Mahabharata, we have the text of what Vyasa has written. Here they don't even provide me text of what N.R. Kamath has written. Ask me to cross-examine. Then they take a stand that strict rules of evidence are not applicable. He has cross-examined at length. Ultimately, I need not tell my lords that it is not the length of the cross-examination. Whether I have been given an opportunity to effectively cross-examine, not cross-examine at length. Then, my lords, in this reply, you my lords will kindly see at paragraph 29, Mr. So and so, there is a Srinivas Padiyar, petitioner. Mr. Srinivas Padiyar, last paragraph at page 119. Assistant Manager, Syndicate Bank, Nariman Point, Bombay, in a statement dated 21/2/95, inter alia stated that he is working as sub-manager at Syndicate Bank, Nariman Point, and assist the manager of the branch for carrying out day-to-day operation. He further stated that with regard to opening of current account, we normally insist on proper current account introduction only attested by the bank officials, either bank within the bank, either from within the bank or any other bank. The account number so and so was open and all that. I say, then my lords, I give complete background of what has happened. Next paragraph, T.P. Kinney, who was co-accused but was held a separate inquiry against him. In his statement dated 21/2, inter alia stated that he is working as assistant manager in the current account department. This is very important for me, madam, because opening of current accounts is the responsibility of the assistant manager in current account department. He says, I am assistant manager in the current account department, Syndicate Bank, Nariman Point. He states that all proprietors of the above concerns have come personally and signed before me while opening the above accounts, and I have been able to identify the above proprietors well presented before me. Well, the allegation was you have not obtained proper introduction. He says all of them have come to the bank. All of them have signed before me. None of them are fictitious. Then, Manoj, today I have been shown 5 persons who gave their statement, out of which I am in a position to identify only one person physically as Sultan Ahmad Khan, proprietor of Mehdi, etc. The said Sultan has given his name as Khan Imtiaz Murtuzar. As a token of affidavit, both of us are signing here below. Out of the 4, I am also not in a position to identify Zakir Hussain, who used to come to the branch doing the transactions of all the 5 accounts. He said Zakir is not having any bank account. However, he was introduced to me by one Mr. Sudhir Zaveri. Then, Manoj, the bank also refers to, from page 122, para 36, these Manoj, absolving part. It can be seen from the above statements that there is nothing to indicate in any of the statements that either his notice is the Syndicate Bank, Nariman Point, Bombay, or its employees were aware of the activities of co-notices or the modus operandi being followed by them, allegedly depositing the sale proceeds of smuggled goods in the impugned 6 current accounts opened in their branch, and the pay orders being taken from them were meant for obtaining foreign exchange for the alleged purpose of being smuggled out of India and for not being legitimately issued for the purpose of realizing the said foreign exchange, that is business travel scheme, business travel quota. It can be seen from the above statements of Srinivas Padiyar and T.P. Kinney that the normal precautions they should take at the time of opening of a current account were taken by them. Normally, while opening a current account according to the guidelines circulated at the banking institutions, inter alia, the following precautions have to be taken. They list 1, 2, 3, 4.
So they say that according to them, he has taken whatever precaution.
Yes. I know, Manoj, for this their answer would be, this is only regarding 6 accounts. What about other accounts? About other accounts, nowhere in the inquiry have they pointed out in these 6 accounts you have taken precaution, in remaining you have not done. Suppose not their stand is, this notice is related only to this 6 accounts. whereas the charge sheet contains 31 accounts. They have to point out that in this account you have not done this, in this account you have not done this, whereas in these 6 accounts you have done everything. My defense is all these accounts are opened by TP Kinney. 4 of them have been opened by Lohitas. I have not opened any account. And here TP Kinney, separate inquiry is held, whereas here statement is in respect of the same accounts. Then, my lords, at the up to para 8, from para 1 to subpara 8 of para 37, bank narrates what are the precautions to be taken and certifies that both TP Kinney as also Srinivas Padiyar have taken all precautions. They cannot invent an additional precaution to frame me in respect of any other account also. Because para 37 is a generic statement.
And these are even these 6 accounts are a part of the.
These 6 accounts are part of the charge sheet.
So there is no explanation regarding the.
There is no explanation. Suppose what the charge box. You open 37 accounts. 6 are part of ARI notice. Additionally, we have found 31 accounts. In each of these accounts, these are the irregularities. And that irregularity should be referable to any of the items mentioned in para 37. Because para 37 is the statement of the bank which says these are the precautions. Then, my lords, at page 123, para 38, the notices would like to respectfully submit that the employees of the bank observed all precautions which are stipulated in the guidelines, and this fact has been mentioned in the statement dated 21/2/95 of Srinivas Padiyar as well as statement of TP Kinney. The notices would like to submit that the accounts were introduced by certain exporters who had their current accounts with Bombay Mercantile Cooperative Bank, and introductory signatures of these clients have been confirmed and verified by the Bombay Mercantile Cooperative Bank. The notices further submit that the current account officer of the Syndicate Bank, Nariman Point, Mr. BP Nayak, this is another co-accused. Against whom separate inquiry was held. Obtained confirmation from the Bombay Mercantile Cooperative Bank regarding antecedents of the introducer over phone in respect of current account number 2873. Further, when the Assistant General Manager R&I visited the branch on 21/2/95, he directed that the branch wrote to Mercantile Cooperative Bank to confirm the signatures of these officials who have verified the signatures of the introducers, while letter dated 21/2/95, copies enclosed as Annexure 2. BMC had since confirmed the introducer's signatures on the account form. One of the allegations in the charge sheet issued to me is that I have not taken care in obtaining the confirmation of signatures from the Bombay Mercantile Cooperative Bank. Then, lords, why cash transactions? Para 40, they explain. The Syndicate Bank, Nariman Point, Bombay, is one of the most important branches of the bank and is located in a business district and has to compete with only not only other nationalized or scheduled banks, but also number of multinational banks. Further, the bank or number of accounts serviced by the bank are large, and the staff are put to considerable strain in managing the bank. The notices are also facing currency shortage. This is very important, my lords. Bank wanted the cash to flow in. The notices were also facing currency shortage in as much as they had to pay huge amount towards withdrawals and their currency just was short of cash at times, particularly for making payments on paydays. In these circumstances, the employees felt the need for receiving cash with an object to overcome the cash shortage problem. One of the main functions of a bank, particularly while dealing with current accounts, is to attract deposits as funds would be available to the bank comparatively at lower cost, which can be suitably deployed for lending. The employees of the branch, keeping in mind this overall objective, have opened the said current accounts in the branch with the bona fide belief that considerable amounts of cash deposits will be received through these accounts. This is the justification of the bank. And it also says there is nothing wrong in receiving cash. In fact, there is nothing wrong in that. Oh my lord, beyond 20,000 if somebody deposits in cash, or beyond 50,000 if somebody wants a demand draft. There also, bank does not say you don't issue. All that the bank says is obtain their PAN number. 1995 is a time when PAN was unheard. Only PAN we were knowing is weighing PAN.
These restrictions were not in vogue, nor were they conscious of this cash deposit.
Yes, my lord, on the other hand, you may not see the notes, currency notes of ₹1 to ₹10, they are treated as coins in law because they are not promissory notes. In 20 also is not a currency. 100 and above or 50 and above, they are not coins. They are legally promissory notes. Promissory notes in the sense, each of the currency notes will contain, I promise to pay the bearer of this 100 rupees, signed by the Reserve Bank government. And in law, as long as the currency note is not counterfeit or it has not been demonetized, everybody is bound to accept. In fact, everybody refusing to accept it, criminal case can be filed against him. Because you are refusing to accept a sovereign bill of exchange.
Legal tender.
It is a legal tender. It is a sovereign promissory note. That is why my lord should find in this 1 rupee note and all that. Government of India and again. 50 because it is not a note. I was doing all this work. 100 rupees and above. Reserve Bank of India answer. The government of India's name never comes. And 50 is there. I promise you. 50 is there. Now 50 and above is a promissory note issued by the Reserve Bank. Agar 1, 2 and 5 months. Then my lords, para 42. The notices also submit that at no stage they had any knowledge or reason to believe that the funds being deposited in the said current accounts were tainted funds allegedly generated from the sale proceeds of from the sale of smuggled goods. Similarly, the notices had no knowledge or reason to believe that they were in any way concerned with the activities of the said current account holders or any persons mentioned in para 28 of the Shokas notice. I do not know what these persons mentioned in the para 28. Maybe all the accounts that they mentioned in the charge sheet are of these para 28 names. Because in the alleged smuggling of gold into the country or the smuggling of the same proceeds of such gold, in the circumstances, it is not correct to state that the notices have abetted the persons mentioned in para 28 of the show cause notice by their acts of omission or corruption. This is the categorical reply of the bank. And para 45. In the light of the above submissions, the notices respectfully submit that they have not violated any of the provisions of the Customs Act. In the circumstances, they submit that they have not committed any offences which they have been charged. They earnestly pray that the charge is withdrawn. Then they reserve the right to add, modify, and all. None of this reply was rejected by the Director of Customs. Penalties were imposed. Against that, the bank filed appeal before SAGAT. SAGAT acquitted or exonerated all of them, Syndicate Bank as well also as my client, which I pointed to my lords from annexure Q, which is at page 5 of my additional statement of facts filed on 1st March 2001.
Yes.
I pointed out, my lord, from this. I will not again trouble my lords reading all that. Kindly see who are the notices there. BP Nayak is the first notice. Syndicate Bank, another notice. AM Subramanian, SR Padia, TP King.
It is joint appeal.
It is a joint. And having taken a stand before adjudicatory forum, by sworn statement, they cannot turn around and say that of these four, only you are bad. It cannot be. If 4 officers want to have to be tried, in the light of this categorical reply of the bank, they cannot be tried. In spite of it, if there is something which is beyond this, all the 4 will have to be tried together. There cannot be independent charge sheets, independent inquiries, independent conflicting conclusions, independent varying discriminatory punishments. That is the reason why regulation 10 is there. Regulation 10 has 2 objects. One is everybody who has played a part, they have to be told role played by each of them. Suppose one current account, it goes to 6 people for opening, or 4 people for opening, or 3 people for opening. Each 3 has to be told the role played by him in a giant inquiry. And then it has to be established. I may say, my role was only this which I have played correct. Somebody may say, I have done my part of the work correctly. James Subramanian will say, I am like an IAS officer sitting at the top of the heap. All of them have signed, so I also signed. I am safe officer. You cannot hold independent inquiries and say that You are guilty of committing wrong in opening a particular account. Everybody is wrong. And the charge sheet does not say what was the role required to be performed by me in opening the account. All these can be candidly and precisely stated if it is in a joint inquiry. And in a joint inquiry report has to be one inquiry report. Inquiry officer also will have to say in respect of each item who was required to do what he has actually done, what is the gap between stipulation and actual performance. Then the magnitude of guilt or the extent of culpability would be arrived at. And on that common inquiry report, disciplinary authority has to take one decision. Then it may be possible he may impose the same penalty on everybody, or he may still impose differential penalties. But for that, he has to say, I find so and so more culpable from the findings of the inquiry officer for reasons 1, 2, 3, 4. Therefore, I impose this penalty on him. Number 2, he has been a victim of circumstances. I absolve him. Like this, he can say. Then, my lords, in this, I don't want to trouble my lords reading this annexure to you again, because yesterday and day before, I have read where the appeals are alone and said that even they say paragraph paragraph 31 onwards, the findings, paragraphs, yes, paragraph 30 onwards. Paragraph 31, what is the function of the bank? Then they proceed to state that bank has performed this job. And it also says there was no requirement to verify, that is at para 34. Ultimately, at paragraph 39, all the appeals are allowed.
Paragraph
39 at page 32 is the conclusion.
At paragraph 30,
yes,
is an observation regarding the employees.
Yes,
made in the order that was impugned.
Yes,
And at paragraph 31,
yes,
at the fourth line, we do not think it is a legitimate function of any bank or official.
Unless the law requires it to inquire into the source of funds. In our opinion, that militates against the general concept of banking. The commissioner's order does not disclose the existence of any legal requirement that the employees of the bank must satisfy themselves about the source of funds. Allegation against me in the charge sheet is when huge pay orders were being purchased, cash was deposited, you did not inquire into source of funds.
Whether we do not find any evidence
that the officials of the bank who were concerned with the opening and operating these accounts or any of their superior officers knew had reasons to believe that what has been deposited in the banks was money obtained by proceeds of sale of goods, sale of smuggled goods. The commissioner himself does not say any such specific evidence in support of his view, even if we assume for a moment that the bank officials acted negligently or carelessly in accepting the response and has contravened regulations of Reserve Bank of India, that is the last 7 lines of that paragraph, as argued by one of the counsel. That is what any commercial establishment would do for a large scale customer. If there's any negligence on the part of any of the employees of the bank, the commissioner was at liberty to refer the matter to Reserve Bank to take appropriate action. We do not take any such reference was made. Here, in fact, as a matter of fact, when I sought Reserve, the inspection report, they did not make up. And it is not their case, even their statement of objection, that Reserve Bank has pointed out any lapse in the part of the bank or its officials. Now, my lords, coming back to what happened in the inquiry, after I read the statement and placed the notice on record, it was taken and marked as taken on record as annexure 1 at page 142. Then I pointed out from page 247 that after marking the document, the inquiry officer refuses to rely on that, saying that it is not properly introduced. Well, no objection was taken at the time of mark. Then coming back to my notes, the evidence that has come at page 126 is the evidence of their star witness, Mr. N.R. Kamath.
One 26.
126.
One page distracted.
I submitted. The page number may be slightly different, but it is 126. Last paragraph. I am Sri N.R. Kamath, working in Vigilance Unit, RI Mumbai, since March 94. Under instructions from Head of Vigilance Cell, I conducted investigation at Nariman Point, Mumbai branch during April 95 and May 95. 21/2/95 was the TRI raid. In the light of it, this was ordered. I found that during the course of my investigation, I found certain irregularities on the part of SR for DR, as if we did not find any fault on the part of anybody else. Inquiry, the investigation report would disclose on who, on part of each and everybody, every person, what was the lapse found. The then sub manager, I identified the documents produced under serial number 12356 of the documents now shown to me. These documents are marked MEX1 to MEX356. He is not the author of the document. All exhibits are marked through him. During the course of my investigation, I noticed that 6 current accounts were opened at the branch on 31/1/95 and 1/2/95. These are the very same accounts which are subject matter of PRI. Then he adds in the middle of that, DRI Mumbai further by their show-cause notice dated 16/8/95 on our Nariman Point sought reasons as to why the amount of cash seized and amount of charges stopped for payment could not be communicated and why penalty should not be imposed on the bank for abatement of offence. Then, my lords, next paragraph, he refers to 11 current accounts. Then he says, Padiyar has not obtained confirmatory signatures of the introducers. Then he goes on saying, and at page 129, now I would like to summarize the irregularities observed by me during my investigation. Then he enlists 11 alleged irregularities. Then, my lords, item number, the irregularity number 11. During our visits to the addresses provided in the appropriate forum. Our means who? Suppose I have accepted one address as correct in account opening, and they want to establish that there is no such person in that address. To the inspection, he has to take me also along with him, like any spot inspection. During our visits, who? Anybody except me. Ultimately, allegation is against me. And the person who accompanied him, even though the law required, I should have been given an opportunity to accompany him. The person who accompanied him, he is not examined in the inquiry. Then, my lords, he does not speak about contents of any of those 356 documents. Contents of the document do not get through by the marking of the document. That is the law that declared by this court in respect of an inquiry held by the Nimans against its officer in the year 2022 itself. I pledge that division bench judgment before my lords. Thereafter, my lords, my cross-examination starts at page 130. I start cross-examining. Question 8 in my cross-examination at page 130. I am placing before you circular number 231/92/BC dated 1/92, wherein item number 4 of the annexure to the research circular states opening of new accounts should be authorized only by the branch manager at larger branches by the officer in charge of the concerned deposit accounts department. Branch manager was assistant general manager Mr. S. Subramanian. It is the stand of the bank, it is my reply also that I was not in charge of the current account department.
It was a branch manager.
Large branch. It is headed by assistant general manager.
So even according to the circular.
Yes, I am not responsible. After referring to that circular, I put him as a solution. Hence, may construe in an ELB like Nariman Point, there is not such exception in a large branch, ELB. The officer in charge of the current account department should have followed all the rules and regulations laid down for opening of new accounts. Yes. Answer of the witness is yes, subject to overall supervision by his supervisor. It is not his case that I am his superior. Then, my lords, from your answer to question 8, it is implied that the overall supervision by the superior in a big branch is post facto. Is it so? No, but it depends on case-to-case basis. In a busy branch like Nariman Point, where variety of transactions including foreign exchange are conducted, is it possible for one sub-manager to verify all the minute details of such and each and every new account that is being opened prior to opening of such accounts, taking into consideration the fact that sub-manager of such a branch has to look after other activities also, such as administration, cash management, etc. Answer is, I am deposing on the basis of my investigation findings. Here again he refers to his investigation. If the investigation report has found all this, best evidence would have been the investigation report itself. Then now, at question number 13, from your answer to question number 12, with particular reference to circular dated so and so, may I inform that the officer in charge of the concerned department should have taken all the precautions before opening new accounts? Answer is, I have already made it clear in the answer given above. Question number 12, the answer is, normally who verifies the account contents filled up by a prospective customer in the opening of form and signature? It is left to the branch head to decide. It is left to the branch head to decide. I am not the branch head. Then, my lords, question number 14. I ask, I have not verified it. Mr. Lohidas has verified it. These are the account opening forms. What do you say? Look at the partisan attitude of this business. I am showing you account opening forms of current account number so and so, where it is amply clear that the introducer's signature and the contents filled up by the introducer, though incomplete, have been verified by the officer in charge of the current account department, and the account opening forms have been signed by the then manager, Mr. Lohidas, as a post facto measure, and GO20 have not been obtained. From what has been stated, may I consider that it was a normal practice and procedure at Nariman Point branch. I have nothing to say. He has investigated every account. Then, my lords, I put suggestions regarding the check discounting and all that. At question number 23, page 133. I make a suggestion about the check discounting and overdrawing. The answer is, it is true that the then AGM had sanctioned the concerned debit balances by marking of DOD and checks, and initiating is indicative of the fact that CSOE has definitely recommended that, although he was not in charge of the. This was a statement to have been made by the person who permitted the overdrawing, Mr. Subramaniam. He admits that Subramaniam has permitted the override. And he says, yes, he has permitted, but you have recommended. My say is, I did not recommend. When I received instruction to pass the check, I endorsed on the check. By passing the check, this will be the TOD cost and send it to the AGM. There is nothing in the check so that I have recommended. In fact, that is my suggestion. You have stated in your disposition that is at question number 23. CSOE allowed debit balances in the current account number so and so, but the records indicate that CSOE had only marked on the face of the check as TOD, thereby indicating to the AGM that the account would result into a debit balance if the checks were passed. In spite of the clear indication, the then AGM authorized allowing of the debit balance in current account. How can you say that? And even if it were to the AGM, could have very well turned down the recommendation rather than allowing the debit balance. Then now, re-examination is there. Question by the inquiry officer. Then Mr. Loidas is examined at MW2 at page 135. There is a person who opened 4 or 5 accounts. Question number 11 at page 138. What was the normal practice followed for opening of current accounts during your period as manager? The practice followed in the branch is that customers used to approach the concerned officers in deposit section who are opening the accounts if they are satisfied about the completion of formalities, including proper introduction. If there is any doubt, they used to refer the matter to either the manager or chief sub-manager or chief manager. He admits that it is the responsibility of the department. This is all the evidence that came on record. Nobody referred to in the evidence this particular account opening forum. These are the defects. You have permitted opening of the accounts. Nobody said that, look, this is the overdrawing cost except in respect of that one check which I pointed out. They accept that it is sanctioned by the AGM. Why the AGM sanctioned? Is it because of my recommendation? What is my recommendation? AGM is not. Then, my lords, the officers who opened the accounts, they are not examined to say that Under my instructions, they opened that. There is simply 356 documents are marked. Contents of those documents are never spoken to by any witness. Somebody has to say, this is the signature of Srinivas Padiyar, who is authorized opening of the account. There is nothing of that sort. Then, my lords, at page 142, yesterday I pointed out to my lords, regulation 615, 6 clause 16, 6 clause 17. They are 3 sub clauses which deal with what is to be done after the inquiry of the evidence of the management is over. First is clause 15 of regulation 6, which require that the inquiry officer on concluding the management evidence should ask the charge sheeted employee whether he has any defense to make. If such a defense is made orally, it has to be recorded by the inquiry officer. If he gives a written defense statement, it has to be taken on record. In either case, copy has to be given to the presenting officer. I gave annexure H. That was marked and professedly excluded for the reason that it is not introduced. Where is the question of introducing a defense statement? Then 616. 616 is leading of evidence from defense side. I may examine myself as my witness, or in addition to examining myself, some more persons I may examine, or without examining myself, I may examine one or two. It is thereafter regulation 617 comes into play. Here, what the inquiry officer does at page 142 is, he asked me to make a written statement. I give a written statement. He marks it as annexure 1. Then, as the CSOE has not appeared as witness, I am generally questioning him in terms of regulation 617 or by asking following questions on the circumstances appearing against him in the evidence so far. Then he knows the contents of regulation 617. He should point to the circumstance and then ask him. It is not a case of inquiry officer not knowing the rule. He states the rule correctly. Then kindly see what are the questions. With your background experience in branch working, did you at any stage feel that the operation in the above referred current accounts are suspicious, unusual in nature? It is not referable to any evidence on record. Therefore, I said I will answer this question in my written book. Because presenting officer will argue. In my reply arguments, I will argue. Then, in view of disproportionately high level of operations compared to the balances maintained in the account, can you tell me the circumstances justification that warranted you to extend service with undue haste? No witness has said that I have extended service with undue haste. It is inquiry officer's evidence. He points to me, MW1 has stated so, or MW has stated so. I can ask him where he has stated so, you point out to me. Here he says, in view of disproportionately high level operations, compared to the balance maintained in the account, can you tell me the circumstances, justification that warranted you to extend service with undue haste. That means he has come to a conclusion, I have extended a service with undue haste. And he wants me to give reason. These questions are not only contrary to sub-regulation 17 of it, it also discloses his predetermination. I am yet to read my evidence. He comes to the conclusion that, can you tell me the circumstances, justifications that warranted you to extend? (617) is not to collect evidence. 617 is made for the benefit of the accused. It is not for collecting evidence in support of the charge. Then third question, have you maintained any follow-up diary in the branch to record important deviations and justification thereof? No witness has pointed out that a record of deviations will have to be maintained along with the justifications in a diary. No circular is produced in the inquiry to say that deviations can be made, but you have to record it in a diary with justification. He presumes that I have deviated. He presumes that there is a requirement to record the deviation in a diary with the justification and ask me a question. Have you maintained such a diary? Do you have anything to say other than what you have said in your defense statement on the circumstances appearing against you in the evidence? He does not say what are the circumstances appearing against me in the evidence. And this defense modes, after all, it can always be said, you are an educated man. After going through the evidence, you should be knowing what is against you. Well, to my mind, what appears as circumstance appearing against me, I can imagine. But I cannot imagine what is in the mind of the inquiry officer as a circumstance appearing against me. I cannot telescope my imagination into his brain. This complete unfairness in the inquiry, perverse thinking of the inquiry officer, and his bias is apparent in this one page. First he says, your defense statement is recorded. Then he says at some other page, I will not look into it. Then he asks these questions. For all the things that has been committed against me by this inquiry officer, I have made him respond alleging personal bias. Then, my lords, I produce two witnesses. There is at page 143. Sudhir Zaveri, who is a person named in the charge sheet. I examined him. He says, what are his banking transactions? Who was permitting him any overdrive? You have to remember one thing, Manoj, he is a customer of the bank. By speaking, he says at page 145, at page 144, middle of the page, about opening of his account. The sentence starts like this. Accordingly, with the help of Malabar Hill branch, we opened current accounts at your Nariman Point branch, middle of the page, at page 144. That Manoj sir.
Accordingly, with help of Malabar.
Yes, sir.
Accordingly, with the help of Malabar Hill branch, we opened current account.
What was accordingly discussed in the past? Because Malabar, the Nariman Point branch was a bigger branch. Then we discussed, because they were earlier holders of accounts in Malabar Hill branch. Then Manoj, Mr. Hegde of Mr. Hegde of Malabar Hill branch personally discussed the difficulties experienced by with Mr. Subramaniam, Chief Manager of Nariman in our presence, and Mr. Subramaniam assured us that all possible cooperation will be extended by the Nariman Point branch to carry on our business smoothly. We started operations in our current account at Nariman Point branch. Thereafter, the current account section of Nariman Point branch was subdivided into two sections headed by Mr. B.P. Naik and P.P. Neef. While some of the accounts were serviced by Mr. Naik, other accounts were serviced by Mr. P. The Nariman Point branch was not fully counted. All those things he states. Then at the last part of his evidence at page 145. Before I sum up, I wish to state categorically that we were dealing directly with Mr. Subramaniam, the then chief manager, and with no other officer of the branch. The credit facilities, if any, that were enjoyed by us at Nariman branch was due to the benevolence of Mr. Subramaniam and none else. Then Manoj, presenting officer cross-examines. At page 146, he again reiterates in the cross-examination, since you are approaching the branch authorities for sanctioning TOD, etc., can you recollect the names of concerned officials of the branch? I was meeting Mr. Subramaniam, chief manager of the branch. Since which date you know SR Padiyar sub-manager? Ever since the opening of the said account, I put it to you that SR Padiyar used to grant you TOD against clearing and ODD. His answer is no. I pointed out to my notes that all the CTDs contain the signatures of the AGM. And this is disbelief. If Subramaniam comes and says that I have not granted any of these things, there will be two characters involved in the chain. Then you can say I believe one, I disbelieve another, for reasons. Here, A.M. Subramaniam, to whom all the excesses are, the excesses which I am not in banking parlance, anything allowed beyond the prescribed limit is called as an excess. Overdrawing or check discounting, if it is done, without there being a limit, you can clearly call as excess in banking terms. He is not, Subramaniam is not exempt. The beneficiary comes and tells that my benefactor is Subramaniam. That is disbelief. Then, Manoj, certain questions are asked. Then, no question is asked to him about his account opening. He stated in his examination in chief that Malabar Hill branch had a discussion with the AGM of or DM of head of the Nariman Point. Through his assistance, I came and opened. Then, last question is, a suggestion is put. That is question number 18. That he was meeting the petitioner. Answer is, I never approached CSR Players Manager for any financial favors such as TODs, CDDs, and against clearing facilities. For that, I put it to you that you are falsely reported. Then, Manoj, I just rush through the
Can we continue?
Yes, ma'am. Now, I will not take much time about evidence. One more witness I examine, that's all I will say. We can continue, Manoj, on facts, accept the inquiry officer's report and the final order. Rest I have concluded. I'll also
Monday and Tuesday, there are some other matters of other rosters. So we'll have it on Wednesday. Wednesday at 2:30. Same at 2:30 after some time.
Very well, very well, very well.
But at serial number 33, there is the interim order to be extended. My apologies, my adjourned.
Serial number 33.
Please, Manas.
The interim order. Yes.
Macho.
Court officer. Sir, serial number 51 ni other one date ಕೊಡಬಹುದಾ? ಹಾ ಸರ್.
2 weeks ಅಂತ ಕೊಟ್ಟಿರ್ತೀವಿ.
ಅಲ್ಲ ಸರ್, ಅದು ಸೀರಿಯಲ್ ನಂಬರ್ 50 ಯಾವುದು ಸರ್? ಅದು ವೆಡ್ನೆಸ್ಡೇ ಅಂತ ಹೇಳಿದಾಗತ್ತಲ್ಲ ಸರ್ ಅದು.
ಯಾವುದು?
ಸೀರಿಯಲ್ ನಂಬರ್ 50 ಸರ್.
50. ಸೀರಿಯಲ್ ನಂಬರ್ 50 ಸರ್. ಡೇಟ್ ಇಲ್ಲ ಅದಕ್ಕೆ ಸರ್.
ಸರ್ ಒಂದು ಡೇಟ್ ಕೊಡಿ ಸರ್. ಅದು ಸರ್ 2013 ಮ್ಯಾಟರ್ ಅಲ್ಲ, ಅದಕ್ಕೆ ಒಂದು ಡೇಟ್.
10 ಮ್ಯಾಟರ್ 11 ಮ್ಯಾಟರ್ ಆದ್ಮೇಲೆ ಬರುತ್ತೆ ಅದು. ಅವ್ರು ಹಾಕ್ತಾರೆ ಬ್ರಾಂಚ್ ಅಲ್ಲಿ, ಅವರೇ ಹಾಕ್ತಾರೆ.
ಯಾವ್ದೋ ಒಂದು ಡೇಟ್ ಸರ್ ಯಾವ್ದಾರ ಒಂದು ಡೇಟ್ ಬೇಕು ಸರ್, ಡೇಟ್ ಅಷ್ಟೇ.
ಆಯ್ತು ಸರ್, ಕೊಡ್ತೀವಿ.
ಒಂದು ಡೇಟ್ ಹೇಳಿದ್ರ ಸರ್, ಒಂದು ಡೇಟ್.
ಓಕೆ ಬರುತ್ತೆ, ನೆಟ್ಟಲ್ಲಿ ನೋಡ್ಕೊಳ್ಳಿ.
ಸರ್ 51ಗೆ ಒಂದು ಡೇಟ್ ಕೊಡ್ತೀರಾ ಪ್ಲೀಸ್?
ಆಯ್ತು.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮಂಜಣ್ಣ, ರೀಚ್ ಆಗಿರೋದೆಲ್ಲ ಏನು ಮಂಜಣ್ಣ? ರೀಚ್ ಆಗದೆ ಇರೋದೆಲ್ಲ ಏನ್ ಮಾಡ್ತೀರಾ?
ರೀಚ್ ಆಗಿರೋದೆಲ್ಲ 2 weeks ಅಂತ ಬರ್ತೀವಿ ಅಷ್ಟೇ. 2 weeks ಆಮೇಲೆ ಬರುತ್ತಲ್ಲ ನೋಡ್ಕೊಂಡು ಅವ್ರ
51 ಡೇಟ್ ಕೊಡಿ.
ಕೊಡ್ತೀವಿ.